Thank you for the cross-examination bundles from the respondent side, so you can now start with your cross-examination.
Sorry, my microphone that I had been previously using wasn't working. Don't know what happened over lunch, but okay. Good afternoon, Mr. Bullard. How are you? As you know, my name is Jennifer Haworth-McCandless, and I am a part of the team representing the Republic of Peru in this case. We have obviously met before. We met before in the Cerro Verde hearing. We have met before in other occasions, in other cases. And I know you know the practice and the rules. I'll be asking questions in English and you'll be answering in Spanish, so we'll need to pause a bit for a translation. I know you understand English and I understand Spanish, so it'll be a test for both of us. But in any case, we'll have to pause, otherwise the transcript won't be able to record what we've stated. And as you also know, because time is limited, it'd be appreciated if your answers are as concise as they can be, and so that we can be efficient with our time.
Perfect.
Perfect.
Now, Dr. Bullard, you state in paragraph 2 of your first report that you are issuing the report. Said I am issuing this expert report independent of the parties and their counsel. And then you state, this report fully reflects my independent understanding and opinion. And then you state that the contents and conclusions expressed in this report are based on my own knowledge and legal analysis of the laws, jurisprudence, and documents referenced therein, correct?
Correcto.
That's correct.
And you confirmed that assertion, I assume?
Sí.
I do.
So I first want to discuss your experience and background. And in paragraph 3 of your first report, you list a number of international arbitration cases in which you've been involved in recent years, in which Peru was a party to the case in any of those proceedings. And you say, and in some, you say you were called to testify as an expert on behalf of the Republic of Peru, and in some cases you're called to testify as an expert or act as counsel, local counsel, in cases that have been held against the Republic of Peru, correct?
Correct.
That is correct.
And in fact, I actually counted the number of cases in which you appeared on behalf of Peru and the number of cases in which you appeared on behalf of claimant in the cases, and there were four for Peru and 4 against, although if you count this particular case, then it becomes 5 against and 4 in favor. Does that sound about right to you?
No los he contado, pero
I haven't counted them, but I think the count is correct. I imagine.
Notice a trend, and the cases in which you acted on behalf of the Republic of Peru occurred, and I'm only going on based on the information you provided here, so I didn't look up the origination of the cases, but you're listing here kind of dates of the hearings, for if they have hearings, or the dates in which there was an award issued. So I'm going on these dates. You indicated that for cases in which there were hearings from 2012 or earlier, in those cases, so it's over 10 years ago, in those cases you were representing, sorry, I shouldn't say that, you were acting as an expert on behalf of the Republic of Peru. Does that sound correct to you?
Yes, that sounds logical. I haven't seen the dates, but it's more or less around those dates.
The remaining cases, those are the ones in which you've either been a co-counsel against Peru in a case, or you've acted as an expert in a case on behalf of claimants. Is that correct?
That's correct, yes.
And the case in which, for the purposes, for this tribunal to understand that we have seen each other in the recent past, with the exception of the Cerro Verde hearing in February, was the Kunturwasi case against the Republic of Peru, in which you're acting as local counsel in that case, correct?
Correcto.
That's correct.
Therefore, even if earlier in your career you were acting as an expert for cases involving Peru, at least in the last 10 years, it appears that you've been acting as an expert or counsel in cases against Peru, correct?
Correcto.
That's correct.
And I looked at your CV, which is attached to your first report, and in your CV, you note that you worked for Studio Rodrigo for approximately 5.5 years. That was from January 1990 to May of 1995. Is that correct?
Correcto.
And to make sure that the tribunal understands, that's the Studio Rodrigo for whom you worked, and you were a partner part of that time. From 1990 to 1995 is the same local counsel that's appearing in this case. Is that correct?
Es correcto, sí. Hace como 30.
Yes, that's correct. About 30 years ago.
Sí es correcto.
And in the SMCV hearing, you confirmed that you were a partner during a portion of that time. Was it for the last 2 years, I believe?
Sí, más o menos deben haber.
More or less the last 2 years, yes.
And I think with respect to specifically whether or not when you were working at Studio Rodrigo, I had asked if you had overlapped with Mr. Luis Carlos Rodrigo, who is acting on behalf of a claimant in this case, and asked whether or not you had overlapped with him. And I think you said, I said, and this is transcript day 8, in the English at least, page 2194, starting with line 1. It says, and you were in the same period of time in which claimant's co-counsel, Mr. Luis Carlos Rodrigo, who is sitting right here, he's still sitting right here, in this case too, you overlapped with him during that period of time, yes, and you answered yes. 100% of the time, I think you answered yes.
Correcto.
You still
That is correct, yes.
affirm that as well right now.
En los últimos 2 meses eso no cambió.
That hasn't changed in the last 2 months.
Claimant's mining expert, Ms. Vega, who testified a little bit earlier today, stated in her first report, and again before this tribunal, that she also worked at a Studio Rodrigo, and she says in paragraph 7 of her first report that she started there in 1994. So did you and she overlap in time, since you were there from 1990 to 1995 and she started in 1994? I assume there was a little bit of overlap.
No que recuerde. Hasta donde yo recuerdo,
As far as I can remember, no. The only lady that was there was Maria Teresa Quiñones, who worked there at the farm. I do not remember Maria Carmen Vega working there during the same period I was in.
Don't remember. I assume you're not suggesting she was not telling the truth and saying she started in
No sé,
1994, but maybe you just don't remember.
o puede ser que yo me esté equivocando.
Perhaps I'm making a mistake or she's making a mistake. This happened 30 years ago. I do not recall. My understanding is that wasn't the case, but I may be incorrect.
Assumption based on statements, but if you don't remember, you don't remember, and you can't say anything other than that. Ms. Vega had testified that at the SMM Cerro Verde hearing, and again, she said it earlier today, that Cerro Verde was a client of the Rodrigo law firm. And I think in the hearing in February at SMM Cerro Verde, you had said you didn't recall, but do you have a better recollection at this moment? She was stating that she recalled that it was a client. I just wanted to see if you recall at this point.
A raíz.
On the basis of the other hearing, I asked the question. When I was at Estudio Rodrigo, Cerro Verde was not a client of Estudio Rodrigo.
Okay. Are you aware that there are emails and correspondence between Cerro Verde and Estudio Rodrigo that occurs during the summer? I say summer from a U.S. perspective. During June, July, August 1994 period. Are you aware that there's correspondence in the file?
No.
I do not.
And just so that I'm not fibbing or making it up. If we could just look quickly at exhibit. You're right. Okay. I won't show that. Okay. She was mentioning also the in 2004 and 2005, I think she was testifying that she provided advice to Phelps Dodge and SMCV regarding structuring of financing for the concentrator. Does that ring a bell? That she said it was in the 2004-2005 period. That's what she testified today. Is that still doesn't ring a bell to you?
No.
No.
Of what Ms. Vega said.
Oh, okay. Well, let me just go and see. I think I'll see if I can find it. Hang on one second.
She testified that Estudio Rodrigo represented the client, but not that she did.
Oh, okay. But fine. Okay, that is actually more relevant in any case. I wasn't necessarily trying to show that she. I will go back. Let me see if I can find where she states it. One moment.
And with regard to your representation, that there are documents on a record that in 1994, Estudio Rodrigo represented Cerro Verde. I wasn't quite sure. Did you withdraw that, or is that still your position? Because if so, please show them.
Yeah, no, I was mistaken with my dates, and I'm going to the discussion that Miss.
So that's withdrawn.
That is withdrawn.
Yeah.
So she had said the question was, and then in 2000, let's see, she said, yes. Let's see here. Oh, the question was, it's okay. This is 4713 at time was 10/25/35. It's okay if you don't recall, but I represent to you that Rodrigo Law Firm provided advice to Phelps Dodge and Cerro Verde in the application of the profit investment program in 2004. And the answer was yes, I saw that on the record, but I don't remember the date exactly. But now when I saw it, yes, of course, starting 2004, it was a client of the law firm. So yes, you're correct. It's a client of the law firm, not necessarily. She wasn't necessarily testifying as to her involvement. But the fact that, are you aware that she made that testimony? Does that refresh your recollection of them being a client of the firm?
No. No.
Sorry, maybe I'm now confused. I understood you testifying that you left the firm at 1995. So when you are now asking questions on 2004?
Yes, you're right. I'm sorry. I am
Maybe
totally,
we can
absolutely mistaken. Nope, you're absolutely right. Sorry, that's all entirely withdrawn. Okay, you don't recall that that SMCV was a client during the time in which you were there. Do you recall if Southern was a client of the firm, of the Rodrigo firm at that time?
Southern was indeed a client when I was there at Estudio Rodrigo.
And at the SMM Cerro Verde hearing, you testified that when you were at Estudio Rodrigo, you advised several companies that participated in bidding and privatization processes in different stages of the process. Is that you confirm that was some of the work that you did at that time?
Correct.
Correct.
And you testified at the hearing that when you were working at the Rodrigo law firm, you saw various matters of privatization similar to discussions having to do with tax stability. Is that correct?
Correct.
Yes, that's correct.
Did you work on issues related to tax stability, or just to be clear, because I wasn't clear, you said it was privatization similar to discussions having to do with tax stability. Did you work on issues related to tax stability when you worked at Estudio Rodrigo?
Me es difícil recordar, participé en varios procesos.
It is difficult for me to remember. I was involved in a number of processes that were related to privatization. That was the privatization stage in the country. So perhaps there were issues that had to do with tax stabilization or legal stabilization. But truth be told, I would not be able to recall this. This happened 30 years ago. I want to be able to tell you if that happened and when.
Thank you. Next, I'd like to examine the basis upon which you reach the conclusions that you state in your reports. And in your first report, in paragraph 11, you state that the purpose of your first report is to, quote, interpret the 1998 stability contract in accordance with Peruvian law and determine its scope, and to determine whether it covered the investment in the concentrator, correct? That's in paragraph 11 of your first report?
Sí, eso es lo que dice.
And
Yes, that's what it says.
the purpose of your second report was similar. In paragraph 1, you say, I've been asked by the claimant Freeport to review and respond to certain statements in the expert reports of Francisco Guigueren, Professor Romulo Morales, and Professor Jorge Bravo, and Professor Jorge Picon. And I gotta get paragraph 2. And you go and you say these statements relate to the legal framework of the guarantees and the interpretation of the stability agreement scope and the implications of the Supreme Court's decision and the prescriptive period applicable to the annulment. Anyway, so you go on to all those different issues. So that scope in the second report was similar to the scope in the first report, correct?
Correcto.
Correct.
And you are, to confirm, you are a specialist in Peruvian civil law, is that correct?
Correcto.
That's correct.
And you're not an expert in mining law, right?
No soy un...
I'm not an expert in the sense that I'm not a mining lawyer, but I've had a lot of experience in mining matters as an arbitrator, as an expert, and as a lawyer.
Look at your first report in particular, where in paragraph 16,
El primero, ¿no?
yes,
First report, right?
and in paragraph 16, you state, I am not a mining lawyer, but for the purposes of this report, I have assumed that the mining law and the regulations of Title IX of the mining law provided that stability guarantees applied to all the concessions or the entire mining unit in which the title holder made the minimum investment required to be entitled to enter into a mining stability agreement, correct?
Es correcto, pero
That's
correct. But I have also reviewed the regulations myself to confirm the conclusion.
In your first, sorry? Yep. Sorry, I'm just asking if that's your statement in your first report. You are stating that you have assumed that the mining law and regulations of Title IX of the mining law provided that stability guarantees applied to all the concessions or the entire mining unit in which the title holder made the minimum investment required to be entitled to enter into a mining stability agreement. You're stating that that was something that you assumed, and you state that in paragraph 16 of your first report, correct?
correcto con la precisión.
Correct, with the clarification made a moment ago.
And then you state that assuming this to be true, the next sentence, it is my opinion that principles of contract interpretation from the Peruvian Civil Code all confirm that SMCV's stability agreement covered all investments that SMCV made within its mining unit during the agreement's effective term. So the basis of that conclusion in that sentence, which you're stating, is based on the assumption of the made in the previous sentence. Is that correct?
Correcto.
Was that
That's correct.
the assumption? Was that an instruction given to you by counsel?
Es una... co-
It is something that I assumed on the basis of what it was explained and the facts of the case. But again, I did conduct my analysis in connection with the regulations to confirm that this was correct.
You would agree, would you not, that if, and just hypothetically speaking, if one makes certain assumptions, and if there is an error in those assumptions, then the conclusions based on the erroneous assumptions can be incorrect. There's a kind of theory of kind of garbage in, garbage out. Are you familiar with that? Would you agree with that hypothetical? I'm not saying it's occurring here. I'm just asking hypothetically if you would agree.
Es-
That's pure logic.
And at the end of your first report in Annex 2, there is an Appendix 2, that is assumed facts. So they're assumed facts, and for the purpose of preparing your report, you assumed those facts. Is that correct?
Es correcto, simplemente.
That is correct. It's simply, well, let's keep going.
My follow-up question to that is, and I think we had this discussion at the Cerro Verde hearing, the February hearing, but just to see if you are you aware that Ms. Vega and Mr. Otto also had assumed facts? And I actually looked at them fairly quickly, not necessarily comparing every single word, but they looked identical to me. Are you aware that that is also assumed? There was also those assumed facts were provided to Ms. Vega and Mr. Otto?
Sí, en la audiencia anterior.
Yes, at the previous hearing, I indicated that I did not recall, but I did review it. And indeed, there is an annex. I didn't review it word by word, but it's quite similar.
I actually have no further questions.
Any questions in redirect?
No redirect questions. Thank you, Madam President.
No further questions from the tribunal. You are released as an expert. Thank you, Mr. Buller.
Muchas gracias.
Then, after everyone got sorted, we can continue with the respondent's expert, Mr. Eguiguren.
Madam President, I just want to let you know that we have uploaded it to the box. We have an issue with the emails, but it has been uploaded to the box, so I wanted to alert you of that.
Professor Egegoren, welcome to this hearing. You have been nominated as expert in these proceedings. I think you were present already earlier today, so we do not need to introduce ourselves. Yeah, I can repeat as you like.
No.
No? Okay. Then we start right away. Can I kindly request you to make your declaration under Rule 35?
Yes. Declaro.
I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you very much. Do you have your expert reports, RER 1 and 6, in front of you? And can you confirm
Yes.
your reports and nothing is to correct?
They are my reports. I signed them, and I believe that there's no errors to correct.
And I understand that you will make a presentation. So please go ahead with your presentation.
Sí. Y solo para aclararle, doctor Iguren.
Just to clarify, Mr. Eguren, your presentation is at tab 3 of the binder you've been given.
Thank you.
¿Puedo empezar?
May I begin? Good afternoon, Madam President of this tribunal, distinguished arbitrators, and I also extend greetings to the attorneys of both parties and all of those who are accompanying us in this hearing. My name is Francisco Eguren. I'm a professor of constitutional law at the law school, at the graduate school of the Catholic University. I am devoted to teaching constitutional law and public law for the last 40 years. I have been a lawyer for 45 years. So I'm getting older. And I wanted to note that with respect to this case, I have prepared 2 reports. In those reports, I have analyzed primarily 4 matters. First of all, what is the nature and scope of the contratos ley, or legal stabilization agreements, based on their constitutional recognition and development in this case, a sectoral law, the general law on mining. Based on this general conceptual framework, I have proceeded to analyze the stabilization agreement entered into in 1998 by Cerro Verde and the Peruvian state, seeking to clarify primarily what I believe is the key debate, whether this agreement granted the stability guarantees exclusively for the investment contained in the project, that is to say, the leaching project, which was part of the feasibility study that was submitted so as to be able to accede to this agreement. That's the position that I uphold, coinciding with respondent, and it's also been confirmed by the Supreme Court of Peru. And in addition, whether it also included any future investment, or in particular, the investment in the primary sulfides plant, also known as the concentrator, as argued by the claimant. I'm going to refer briefly to each of these points. First of all, what are, according to the constitutional and statutory framework in Peru, contratos ley, or stabilization agreements? We begin by noting that the 1993 Constitution of Peru is the only one in the hemisphere, as far as I know, perhaps the only one internationally, that has a constitutional provision, Article 62, second paragraph, that accords constitutional treatment to what we call contratos ley. And what does that entail? Well, these types of agreements, which are made in order to attract investment and to provide assurances and special guarantees to investors, well, if one had to say it very briefly, what is the main protection that they provide? Well, that those benefits and those guarantees included in the agreement cannot be modified by any future law on this subject matter. Therefore, this guarantee of immutability, this constitutional armoring, as the Constitutional Court has said, in respect of the contratos ley, is an exception to fundamental constitutional rules and principles, indeed fundamental principles of the law anywhere, which is that the law applies immediately as of its coming into force, as of its promulgation and application, that it is general in scope, it governs all under conditions of equality. This is not the case in contratos ley with respect to the guarantees incorporated in the agreement. It doesn't matter what a future law may say. It will, those who have such an agreement well, it applies exclusively to contractual stipulations contemplated expressly in the law on mining. This benefit, this guarantee, has to be interpreted as a provision that is an exception to the constitutional regime, and therefore it has to be interpreted in a strict, restricted manner, circumscribed exclusively to that over which the guarantee was provided. And in the 1998 agreement, the only investment project based on the feasibility study that's included in the agreement and is therefore protected by the guarantee of stability and immutability is the leaching project, and not any other type of project. Now, these contratos ley, and I'll go through this quickly, I've developed it in my report. Well, the claimant and my dear colleague, Mr. Bullard, argues that these are strictly civil law agreements. I am of the view that that is partially correct and therefore imprecise. Stability agreements are a sui generis, special category, mixed in nature, that combine elements of public law that are imperative and administrative, such as, for example, what's the minimum amount of the investment to be made, what is the term of the contract, and most important, what will the guarantees be, the subject matter that will receive the guarantee of stability. But this public administrative nature in respect of the drawing up and entering into of the agreement is supplemented by the civil dimension of the contract, which refers to performance of the contract. Therefore, it is civil in nature in terms of its performance, but not in terms of the drawing up and entering into of the agreement. And what does the civil nature imply? That the parties, the state and the investor, are in the same situation, and unlike administrative contracts, the state doesn't have exceptional exorbitant powers. It cannot unilaterally modify the contract, nor can it apply new laws to it. And this is recognized in one way or another by the claimants themselves and their experts, because they attach a quote which appears there, and Antonio Pinilla, who they cite, states that these agreements are of a mixed nature. So I'm not the only one who says this. Now, one point that does mark a very important difference of interpretation has to do with the adhesion contract nature of these agreements. The law in mining says that these agreements are entered into by adhesion. And from that, the claimants and their experts deduce that because it's an adhesion contract, a principle of interpretation is applicable, which is also reflected in the Civil Code, which is the counter-preferential interpretation. That is to say, in the case of any obscurity, doubt as to the interpretation of a contractual clause, one must embrace the interpretation that most benefits the party that did not draw up the contract. In the abstract and in general, that's fine. I have no objection to it. The problem is that had the claimant and its experts taken time to analyze this particular agreement in the case of mining and the Cerro Verde Mining Company, they would have to realize this is not a typical or common adhesion contract. What is characteristic of a common adhesion contract? One of the parties unilaterally drafts what is so-called the strong part of this imbalanced relationship. That is to say, they draw up the contract generally seeking to protect its own interests and limiting its own responsibilities, and the other party either accepts it or doesn't. That's typical in an adhesion contract, and therefore, because of this inequality, there's generally detriment to the rights or interests of the other party. Does that happen in this case, in the adhesion contract in mining, or in this 98 stability agreement? No, that is not the case here. First of all, it's not that the administration draws up the agreement or its clauses as it wishes. As was already said, and there's no question about it, there are certain stipulations that come from the general law on mining, and no, there can be no discussion of those. They are not negotiable. What the length will be, what's the minimal investment, how long will the agreement last, and what will be given, what will be covered by the guarantees. But the investor doesn't have the passive role of an adhering party who just looks at and can't even discuss, simply signs. Because the general law on mining indicates clearly that to be able to enter into this agreement, the investor draws up and presents a feasibility study, a technical economic feasibility study for an investment project. Who draws up that study? The private party. What are they going to devote the investment to? They decide it or propose it at any rate. How much will they spend, invest? How long will they take? What activities will they carry out? How long will the production take? What will be entailed? All of that emanates from the study that was drawn up by the private party, and that will be part of the contract. If we look at the 1998 agreement, while it's true the Peruvian law says that there's a model, the model speaks to what aspects shall be included and what structure will the agreement have. But when we talk about a model contract, sometimes if one is going to enter into a bank contract and such, they're all the same. I heard in the February hearing someone said, all of the mining contracts are the same. No, that's not so. They may have a like structure. They might have a part that is the same, but a large part of the contract is determined by the feasibility study, which was prepared by the investor. In an adhesion contract, the one who's going to sign it, the one who is, quote-unquote, the weak party, doesn't incorporate parts of the contract. And if we look at the 98 agreement, there are any number of stipulations about the leaching project, how much is to be invested, how long is it going to take, what is going to be purchased, and so on. So it's not a typical adhesion contract. And finally, and most important point, the stabilization agreement grants benefits to the investor. It does not is not to the detriment of its right. What's the great benefit? The immutability, the intangibility of the guarantees set forth in the contract, in the agreement. Therefore, this is not a typical adhesion contract, and that is something that needs to be analyzed because it has legal implications. The general law in mining clearly notes at Articles 82 and 83, particularly the last paragraph, that it is essential to present a feasibility study and that the investment or guarantee is going to cover that investment. The key word is investment, because it says that the aim of stabilization agreements is to attract investments. It's not, as has been said here, that the guarantee is granted to a concession. The concession is a right. It's an asset. Contracts are entered into as among persons, and the guarantee is granted to the investment. If there's no investment, well, it's not an initial investment, as it says. The investment and the investment project set forth in the feasibility study, which is drawn up by the private party, and which the state then evaluates and approves, and which is then incorporated into the agreement, well, it's been said that, well, there's a specific reference to the feasibility study in several parts of the agreement in Annex 2 of the contract. And so the investment, the feasibility study that is presented by the investor is the starting point for filling out the content of the agreement. Article 85 of the General Law on Mining says that one must present a feasibility study, a technical economic feasibility study, that is equivalent to the investment program that is to be approved by the Director General of Mining. The claimant and its experts argue that this is an initial investment that is reflected in the agreement, and that this provides protection for any future investment. In some of the opinions say any future investment. Others say that it is for further investments within the same concession. This doesn't make sense. First of all, the law doesn't say so. There's no article that says the agreement grants contracts of guarantees of stability with respect to what's set out, and plus any future investment. Such an article doesn't exist. Over any investment in the same concession, such an article does not exist. Incomplete reference is made to the regulation, but the regulation is subordinate to the law, and it cannot say anything beyond what's in the law. So the key word, I repeat, is investment. And it's the investment that is made, in effect, circumscribed to a given concession or concessions. That obviously is what is guaranteed, but not the concession, the investment. Otherwise, what sense would it make to submit an investment project or a feasibility study? It's been suggested this morning that it suffices to make an initial investment and win a privilege not only for that investment, but also for any future investment, and including other past investments. Well, where is that? That would be great. One might say, what a great business. I pay 1 and I take away 5. I don't think that is the legal interpretation. I don't know of anyone in the national doctrine or case law having upheld that position, except, of course, after the judgment of the Supreme Court, to which we will refer afterwards. The contract makes several express references in many clauses to the leaching project. The agreement is not a blank check. According to Peruvian law, these contratos ley respond to a public interest, a social interest that the state has to evaluate based on the proposal by the private person. If it were a blank check, then the feasibility study would be useless. It would suffice to say in the agreement that any investment made by this company on these concessions is covered. That's not so. That's not what the agreement says. It's not what the law says, nor is it what the Peruvian case law has to say on this matter. Now, the Supreme Court in 2013, Cerro Verde filed 2 administrative proceedings, and one of them was with respect to the royalties assessment for 2008 and another for the royalties of 2006-2007. The first, the 2008 case, concluded with a decision of cassation by the Supreme Court, which found that the action was unfounded in all its aspects. In other words, the primary sulfides plant had to be subject to the payment of royalties. Now, with respect to the 2006-2007 royalties case, the judgment at trial and on appeal rejected and dismissed Cerro Verde's action, and the Supreme Court held a cassation hearing. I was there. I participated there as part of the defense of Sunat, defense counsel for Sunat, and before the judgment was handed down, Cerro Verde abandoned the case, and so the judgment on appeal dismissing the action was firm. It was said in opening arguments by the claimant, and it's been repeated here, a partial reference has been made to my statement as to whether or not this cassation is a precedent erga omnes, which is to say binding on all judges and parties. My answer has been, quite sincerely, no. But that cannot lead one to underestimate or minimize the scope of this cassation, so much both because of what cassation means in Peruvian law and because of what was resolved in the specific case regarding the interpretation of the Supreme Court, or by the Supreme Court, of the law in mining, the 98 Stabilization Agreement, and what it protected and what they protect and what they did not protect. Cassation is a special appeal. It's not a regular appeal before the highest judicial body of Peru, the Supreme Court. What is resolved in cassation is res judicatas between the parties. That's it. No court in Peru is going to be able to review or change what was resolved by the Supreme Court with respect to 2008 royalties, nor with respect to 2006-2007 royalties, which is a firm decision. It's res judicatas between the parties. So it is not a precedent unless the Supreme Court says so, and it did not say so in this case. Now, what is the value then of it? Well, one minimizes it and says it might be, well, it's not just anything, not just because the Supreme Court has said so, but because it set forth a specific interpretation. What was resolved in the cassation by the Supreme Court is a reference that will have to be taken into account by all judges, all courts, and all lawyers in similar cases. It's possible that one might move away from this reasoning, yes, but it would have to be because of differences in circumstances in the case, perhaps a legislative change. It would have to be adequately justified. Thus far, what has been resolved in this precedent has not been subject to any change by any other court. That is to say, in fact, it has been serving as precedent, quote unquote, and of course the tax tribunal has been citing it and applying it in several similar resolutions. So that it could, technically speaking, there could be a different interpretation in a case other than the 2008 and 2006, 2007 royalties cases. Yes, it's a possibility, but it would have to be adequately justified, and I doubt it because the interpretation of the 1998 agreement would be the same, and the Supreme Court already did so. And to conclude, what did the Supreme Court do? Well, that the guarantees and benefits of stability are granted exclusively, and it says exclusively only in respect of that investment project contained in a feasibility study that was incorporated into the agreement. And this is the thesis that we have been arguing. And it's not a premise. It's not that we assume this. We have upheld this position, and the Supreme Court has said that's so. One may take issue with it, one may criticize judgments, but they cannot be ignored. In this specific case, in both proceedings pursued by Cerro Verde, as from the appeal, I participated, I said in my CV, as an attorney who joined or who worked as defense counsel for SUNAT in these cases. This topic has been discussed before SUNAT, the revenue body, before the tax tribunal, and then before the courts of our country. And in both cases, both administrative and judicial, the position of the claimants, which is the same as the position upheld by Cerro Verde, was dismissed. And therefore, it is a case that's been extensively discussed and debated in Peru. So, to conclude, the stability agreement of 98 entered into by Cerro Verde and the state is of mixed legal nature, and while it is entered by adhesion, the adhesion is with respect to the guarantees, the benefits, the duration of the agreement, which are not negotiable. But obviously, the investor, through its feasibility study, provides a number of elements that are going to be included in the agreement. So it's not a typical adhesion contract. Therefore, there should be no methodical application of basic principles, and one would have to say that the interests of the company are prejudiced. The 98 agreement protected exclusively the investment in the leaching project. The agreement itself, as was discussed earlier, allows for the possibility of expanding the guarantees to other rights and other benefits. Well, that could be done, but the company did not do so. It doesn't have any sort of an agreement whether to amend the 98 agreement or any other agreement that would protect the investment in the primary sulfides plant, also known as the concentrator. Therefore, the agreement always referred to the leaching project. And what was resolved by the Supreme Court, which is res judicata in respect to the subject matter that it resolved, the 98 agreement, and the 2008 and 2006-2007 royalties, is res judicata. This means it cannot be reviewed by any Peruvian court. And while it's not a precedent erga omnes, there might hypothetically be a different decision. There would have to be a different situation. The courts would have to argue, it would have to be the Supreme Court, that based on this criterion, they would have to explain why what was established by the Supreme Court would not apply to the case before it. But that has not happened for the time being. And with that, I conclude my presentation. Thank you very much.
Thanks, and with your permission, I will start asking some questions before we enter into the cross-examination like I've done before with experts, because then for me it's particularly helpful and makes the listening to all other questions easier. You walked us through the hierarchy of norms, and you explained the constitutional particularities of this adhesion contract, and then you now went further to explain your understanding of the mining law, and I understand you testifying that the Peruvian mining law, in your understanding, promotes investments, but does not necessarily relate always to the concession. And we had this subject also addressed by the claimant's expert, Mr. Otto. And he testified something very different. He said there is a worldwide assumption that stability agreements cover all investments in a mining unit, and therefore neither worldwide nor in Peru was this ever an issue. What we have here now to decide in this arbitration, it is a new and novel approach to focus on the investments as opposed to the concession. What is your response to this testimony of Mr. Otto?
I didn't hear what Mr. Otto said, but I can hear you, and I cannot agree, because my report refers to how to interpret the contract, the contrato ley, and the stability agreement based on the Constitution and the Peruvian mining law, as well as the case law, the Peruvian case law. And based on those sources, that is unsustainable. I don't know if in any site that is interpreted differently, but I would need to see a judgment of the Supreme Court of Justice telling me, or any article of the mining law showing that the guarantee covers not only the investment but anything, or a clause of the 1998 contract that would provide for that. But of course, in the interpretation of the law, I have not found that, and also because of the exceptional nature of the contract under the Constitution or in the case law, I have not found anything other than those saying that. So at any rate, the Supreme Court of Justice does not agree with that.
Seen a judgment or legal authority? Are you aware of any minimum practice that would confirm the notion that claimant here argues?
As I mentioned before, I am a professor on constitutional law, public law. I do not have specific information on mining activity, but I do know what the law says and also what the resolutions provided for. So no, I do not know that, and I have not heard in the presentation by experts or in the opening statements by claimant any reference to a Supreme Court of Justice decision that would support that interpretation.
And again, my question relates more to the administrative practice on how to deal with such stabilization agreements. Are you aware of any administrative practice with regard to other mining companies or other mining concessions in which the stability agreement extended to the new investment regardless of the timing, scope, and whether they were covered by the feasibility study?
Detailed knowledge of the practice? No, I do not have, but I think that when Cerro Verde entered into an agreement in 1994 for 10 years, and 4 years after he entered into the 1998 agreement on the same concessions, because they are the same concessions, that contradicts their argument. If they already had an agreement for one investment, for those investments in 1994 for 10 years, why is it that in 1998 they entered into a contract in the same concession but on leaching? Their own acts contradict their arguments, and also based on what I have heard and also what I have seen in this type of proceeding and read, various companies have several investment projects, several or different stability agreements. They may have more than one on various investments, because the purpose of the stability agreement is to confer guarantees for the benefit of that investment that clearly is part of the concession. It is not just for any investment or any concession, but once again, I am not aware, I have not heard by claimant so far that they have had any reference to that type of decision. Whether it was the practice or not, I'm not qualified to say that, but the practice should not go against the law, and the law does not state that.
Then I move on to my next set of questions, which is more related to the contract interpretation, which you also covered in your first expert report. There you said contracts are obligatory insofar as this has been expressed within them. It is presumed that the declaration expressed in the contract follows the common will of the parties, and whoever might deny that coincidence must prove it. This is in paragraph 72 of your first expert report, and you refer to Article 1361 of the Peruvian Civil Code. Do I understand you correctly that first it is your view that is on the claimant to prove that the stability agreement covered the concentrator?
Sí, usted lo ha dicho muy bien, por eso ni siquiera.
Yes, you have said it perfectly well. That's why I haven't even looked at it, because that part of my report goes back to the civil code that states that whatever is stated in the contracts, I understand, are the will of the parties, and whoever says no has to prove that, has to evidence that.
The question, if I understand you saying that this contract, be it an adhesion contract or not, constitutes mutual obligation, does this mean that if stabilization to the concentrator would be granted, then this also entails the obligation to build the concentrator? Is it a mutual concept, or do I understand this not correctly?
I don't think I understood the question very well, but I hope I understood enough to answer, or if not, you can tell me and I can expand. In my first report, I would say there is an equation. The private party will make an investment, a specific investment that is based on a feasibility study and an investment project that the mining division within the state will assess it, and if accepted, it will be part of the contract, and the contract will be approved. That compels the state, as the other party to the contract, to be included to guarantee a special regime of immutability for what is provided for under the contract, as well as intangibility. The plant, the primary sulfide plant of the concentrator may have been part of discussions. The state may have known about it, but that is irrelevant. It has to be provided for under a stability agreement as an expansion, as an amendment of the 1998 contract, or as a separate contract. Therefore, there is no obligation to confer stability or immutability legally from the state in connection to the primary sulfide plant.
This answers my question. I wanted to understand just better the principle of consideration under the Peruvian law system. Now I come to my last question for the moment, relating to paragraph 78 of your second report, RER 6. There you noted the construction of the primary sulfides plant was not subsequently incorporated by the parties to the 1998 stabilization agreement and was not part of a specific agreement signed with the state that granted stability guaranteed. So this is what you just mentioned. We do not have an amendment. But assuming that Cerro Verde has sought such an incorporation, based on the understanding that the concentrator was covered by the 1998 agreement, but this was denied on the grounds that the extension of the beneficiation concession would already have this effect. So going on the assumption, now Cerro Verde received a confirmation, just let us extend the beneficiation concession, then you will be covered. Does such an effect exist under Peruvian law? Can the extension of a beneficiation concession 8 years later have the effect of, so to say, retroactively making everything safe under a stability agreement? What is your view on that?
I already said in my presentation that contrato ley, the law contracts and the stability agreement in mining are part of a regime that grant a special treatment. And I need to be very rigorous because this is an exception to constitutional provisions. The Peruvian state is also entering a commitment for future Congresses and future administrations under the legislative power they have. This is something really serious, and if under civil law the code states that contracts are binding as to their provisions, I cannot assume with expansion interpretation to extend benefits and guarantees that are not part of the contract for investments that are not in the contract when the contract and the law establish the possibility to have a special process to include that as part of a contract in force or a special contract, but never retroactively, never. In Peru, the laws are not retroactive. How could it be that a privilege, a benefit, will be interpreted retroactively as if it was almost suggested? This is an irony. As I said, okay, you buy one, but you get 5. So minimum investment and whatever happened when the contract was not there will be benefiting from that. I never heard of that anywhere else, and I cannot agree with that interpretation. Good afternoon. It's a pleasure to meet you. You have been the attorney that had both cases of Cerro Verde for SUNAT against Cerro Verde. It is correct, but I heard the word represent. SUNAT had its own attorney general, and I was just called to cooperate with the defense. I have participated in the reports and in the hearings. And how then should we understand your participation? Are you here in this arbitration as an independent expert? You're not here as counsel, but as independent expert. That's my understanding too. And if you're here as independent expert, you are giving here an opinion that is different from the one that you offered in the legal case. Is that correct? No. In the hearing of the other case, there was a similar situation, and I explained the following. First, I am an independent lawyer. I am a university professor that also practices law. When I started to participate in this proceeding, as I usually do, I reviewed the claim. The claim had already been presented by Cerro Verde, and SUNAT had already replied. So I came here in second instance, I reviewed, and I said, I agree with this position as presented by SUNAT. And I said, yes, this is what I teach at the level of the university courses, and this is part of the contrato ley. I feel I am identified. I usually participate in cases when I agree with the case itself. So I have not said anything contrary to what I said in the proceeding or in my report. I understand, but we are all attorneys, and we know here that the attorney has one role when he or she is defending a case, and then is a different one from providing an independent opinion. So here you are here with an independent opinion, or are you here as a lawyer? I want to see how to assess your report. Well, from what I heard before, everyone who participated this morning had some sort of relationship with the case. I said in my resume, in particular, that I have been counsel with SUNAT along this proceeding. Now, if that creates some bias, I would tell you that I do not say things different from what I had. So should this be an independent opinion or the same position that SUNAT or Peru had in the litigation? Would you be able to contradict SUNAT? Not in this case. In other cases, I would. In some cases, I've been litigating against SUNAT. Are you here to present your opinion or SUNAT's opinion? I am presenting my opinion. That was the one that I upheld in the oral proceedings, and that is the one in which I believe as a professor. Because if I look at paragraph 10 of your first report, you are saying that here you are supporting the legal arguments of your interpretation, but that was SUNAT's interpretation. I would say that it was my interpretation, but here you're saying it was SUNAT's. No, I apologize, no. SUNAT had been losing these proceedings. We're talking about your position. This is what I am trying to understand. I introduced in the jurisdictional case some elements that had to do with the constitutional position. I introduced some elements that are my own elements, the elements of Francisco Uriguren. Yes, But Sunats was merely accidental. Yes, but thereby you were the attorney. Yes, and you with your own. You are free to believe that and interpret that, and I know that that is a limitation, and I stated that in my report. Now, does that disqualify me to have a legal opinion? That depends on interpretation. You do not need to believe me, but you just said that you wouldn't be able to contradict what Sunat said. You wouldn't be able to disagree with what Sunat said. Do you have any differences with the point of view of Sunat? Well, what I am stating here, and that is what I said in the proceeding, in my opinion, they agreed with my approach, and I agreed with theirs. So there was another aspect that had to do more with taxes, and that was their opinion. Thank you. Professor, I would like to ask you, assuming that the now claimants went to your law firm office back then when they had some doubts about the investment for the concentrator, and they had heard what they called as gossip at the ministry. The vice minister said one thing, the director general said something else, and even the director general said that the decision by the Constitutional Tribunal was unheard of. So this is perplexing to any foreigner. What would have been your advice so as to have some certainty prior to the investment that the investment was going to be covered with the stability? Even though investments are not my field, but as anyone that will be making an investment, I am cautious, and I'm usually fearful in that area. If I am going to invest millions, I would like to have the absolute certainty that they are protected. And if I was asked as a lawyer, I would have said, in the law, I do not see anything clear that states that any new investments are going to be protected. I do not see this in the law. I do not know of any case law that has stated that. I would say, first, either get the amendment to the contract or get a new contract, but I shouldn't make the investment before getting the certainty. If I do not have the certainty, if I do not have an amended contract, personally, I wouldn't feel comfortable because administrations change. Then I would have been a little bit more cautious, and my recommendation would have been not to do it without that certainty. But the client would tell you gossip at the level of the ministry, tell me that if I present in writing a request to get the stability coverage, it will be denied. I do not want to submit it, but I am very interested in the investment. It is quite productive, and let's move forward. In these circumstances, Senat imposes some sanctions. They would like to charge some interest, and they come before this arbitral tribunal and tell us that idea that you are going to impose sanctions that is contrary to the fair and equitable treatment. Do you believe that that is contrary to fair and equitable treatment for someone that is making that investment in that fashion is imposed a sanction? Do you think that that is contrary to equity or equality? There is a principle under the law that says that any law mistake does not warrant the actions. An investor could have understood that they were protected, but if we are talking about stability contract and an exceptional regime, I take my own certainties, and if I took a risk, it means I may be successful or not. So I do not believe that this is something on equal terms. As I just told Madam President a couple of minutes, there was more than one stability contract in connection with more than one investment with Cerro Verde. So if I have a contract and I believe that everything is protected, I do not need another contract for other investments under the same concession. I have even more reasons to look for that contract. But the project may not seem important, the state is not bound, but I may wait until I hear and then I make the investment. But if I move forward, I make the investment, and then I have some tax penalties, is there any path under Peruvian law to tell the tax administration, listen, do not exaggerate? Because since there was so much gossip, I do not have any certainty. Those sanctions are against equality or equity, and is there any path for the tax administration to act in favor of the taxpayer who made the investment because of the gossip, and as a consequence, the tax administration does not have standing to impose those sanctions? Well, I may not remember the name of the case, but there is one of a tax-paying company. I think it had to do with an additional tax on income or minimum income tax. But Sunat said in this case there was a margin to have some opacity or doubt as to the application of the law. And if the taxpayer interpreted it wrong, there was a reason for the mistake because of the ambiguity in the law. Therefore, we will waive any payment of interests. So there was a reason why that party may have acted wrong. There wasn't bad faith. So it is an exception. That case was quite an exception, and it was presented in connection with the conduct of a taxpayer. Now, when there are lawyers in between, it is different, but there is a possibility. But you maintain that the tax administration has the discretionality to condone those sanctions. Is that what you're saying? No, I am referring to a Supreme Court of Justice decision. It is very important for you to refer to the Supreme Court of Justice when your intervention today, you were based on the importance of the decision of the Supreme Court decision. Yes, but I was referring to a very specific case in connection with that taxpayer, and a law in particular that could have a contradictory interpretation as to the time it was going to enter into force. It is not similar to what we are discussing right now. Let us assume that the taxpayer in this case says, you know what, I have been discriminated. There are other cases in the world of mining whereby coverage has been afforded in situations similar to mine, and it was denied to me. This has a political motivation because Díaz-Canseco and others in Arequipa, other representatives, were asking for a hard position in connection with the Cerro Verde investment. This is discrimination. Since there is discrimination, all of this treatment is contrary to equality in treatment. Well, it would have to be evidenced. They would need to show how other companies under similar contracts had that benefit. The reason for the contract to be signed by adhesion as to the benefits, the guarantees granted under the contract is precisely to avoid that. That is to say, transparency, legal certainty. Any investor that meets the requirements under the law that presents the study, and this is considered a national interest issue, has to have access to the same benefits to avoid the under-the-table negotiation with corruption when some officials may offer some benefits or beneficial treatment beyond the letter of the law to some investors, but those cases would need to be evidenced. Discrimination cannot be allowed or tolerated, but it has to be evidenced, not assumed. So in the example that you mentioned, I do not know whether there is any specific reference to this company that was interpreted one way or the other. And according to your legal judgment, which is of high interest to me, if the taxpayer in this case were able to say, I was deceived because we have heard time and again that the company felt betrayed by the treatment they received. I was asked to contribute millions of dollars as part of free contributions for the benefit of certain activities, charity activities in Arequipa, because it was assumed that they were going to give me this stability coverage and it wasn't given to me. I have been deceived. What is your reaction from the legal point of view given this idea?
Well, you're asking me to analyze something that was not part of my report. Well, you're a constitutional lawyer, and as an expert, I'm asking you for your opinion and to react vis-a-vis an argument like the one I'm putting to you. Well, see, facts had to be evidenced and grounded. Perhaps there are some circumstances like the ones you pointed out, but to analyze contracts and the constitutional framework of contractus ley and the benefits, well, I think that has to be looked at from the historical viewpoint. Who did it? Why did they do it? But if we look at commitments and contracts formally, in order to maintain that position, I would have to show some kind of document, some kind of piece of evidence that is irrefutable, that I was told this, and then that under that supposition, I acted in good faith. But here, it is supposed that the investment is made after the project was, after the agreement was entered into. And it doesn't cover prior investments. That's not technically true. Okay, there may be a lot of details here, and what you say may be true. Perhaps it's true. But you, to have stability, you need an agreement that grants your investment stability in those concessions. Do you have it? No. Okay, all else is gossip, speculation. But gossip, I don't think, is the source of a contract. Why is it that you're going to make an investment if you don't have the contract? One last question. I think you are going to tell me that you're not a tax lawyer, but as a constitutional lawyer, I would like to know your opinion anyways. Why is it that they say that royalties are not a tax? That is a very complex issue, sir. I'm going to give you a formal answer first. Well, it is so because the law says so. When the law was passed in Congress, it was said that royalties are contributions resulting from the exploitation of a resource that is not finite. It is assumed that it is not a tax because the law says it is not a tax. But that's part of the administrative realm. It is quite complex, this matter is. We should have a specialized discussion with people that have tax knowledge to say whether this qualifies as a tax or not. Undoubtedly, it is a payment obligation. This is different from the tax on income. This was discussed when an action on constitutionality was brought against an issue of mining royalties. I was a lawyer, and I was part of the Constitutional Tribunal, and I said that royalties were constitutional, and the Constitutional Court so declared. An important part of that debate was whether they were or not a tribute that was duplicating income tax or an administrative payment that was doing also working and duplicating the derecho de vigencia. The validity fee. Okay, basically they say that the royalty is a royalty. Okay, you say royalty is a royalty, but this tribunal has to apply in a TPA. And the TPA says that taxes are excluded from the coverage of this treaty. Perhaps this idea of tax or royalty for purposes of the treaty, well, perhaps that's different from the internal concept that you have in your country in the field of tax. Perhaps when the treaty talks about that taxes are not going to be covered by the treaty, from the international viewpoint, perhaps royalties need to be dealt with in the same manner as taxes. Constitutionally, how would you react to that? I'm not sure if the answer is constitutional in nature. This is a very complex issue. Many of us get confused, and oftentimes when we talk about royalties, we talk about taxes as well. If you're asking my opinion without any kind of commitment, I don't know the treaty and I don't know about those things, truth be told. But if you ask me, I think royalties are much closer to being taxes. Excuse me? Royalties are much closer to being a taxable contribution, a contribution. It is very, very close to a tax, I think, a tributo, we call it in Spanish. And the taxpayer has other contributions that he must make, which is income tax, for example, paying income tax. So this is not a tributo, but it is rather a payment. I think a royalty is closer to a tributo, not only because it has to be paid by the taxpayer and because it emanates from the law, and it has to do with the exploitation activity that it conducts. But I'm not qualified to answer this. It's a matter of opinion. The law said that royalties were not taxes. Okay, they were not taxes, but the signatories of the treaty, the U.S. and Peru, well, what they wanted to do was to exclude actual or fictitious taxes. And a royalty from the viewpoint of the taxpayer, well, the taxpayer sees the royalty as a tax. Well, it is a tributo, and if we were to reinterpret those things, I don't know what would happen. I'm not going to try to commit to anything. I think that royalty is closer to a tributo, but that is my opinion. This was not discussed in Peru, and the tribunal said that the law was constitutional, and that is what happened. The law has been abided by. Thank you very much for your answers, and I am asking you to excuse my insistence. Yes, of course, we have to think about this much more and I have to study much more. Thank you.
Then we hand over to the claimant for...
Thank you very much, Madam President. Before I start with the cross-examination, I just wanted to state it clearly for the record that with the greatest respect, no jurisdictional objection has been made that the royalties would fall under the tax exemption. So that issue is not before the tribunal. Good afternoon, Mr. Eguiguren.
Muy buenas tardes.
Good afternoon to you, sir.
It's a pleasure to see you again.
Para mí también, y
It's a pleasure for me as well. I hope it will continue to be a pleasure after this cross-examination.
We were talking a little bit about your representation of SUNAT.
I'm so sorry to interrupt, but we haven't received the binders. The crop
Sorry for
binders.
that. They're coming right now. Mr. Egiguren, is it correct to say that you led SUNAT's defense in the contentious administrative proceedings before the appellate courts and the Supreme Court in both the 2006-07 royalty case and the 2008 royalty case?
Yes, I think I used the word leader in the other hearing as well, in the sense that I was hired because of my academic background and my experience and my age. I think I had a substantial, influential role in justifying the defense of SUNAT.
Sorry, I don't seem to have Spanish transcript. Anyone is having the Spanish transcript? Oh, there it appeared. Okay, thanks. It appeared now.
Great, thank you. So, Professor Egiguren, you prepared written submissions in the 2006-07 royalty court case for the appellate court?
I do not recall. My role was more to discuss strategy, to design the strategy, and to participate in the oral hearing. Internally, I prepared some documents. I wouldn't want to say no, because there may have been an exception, but generally I did not prepare the pleadings. The pleadings were prepared by the Attorney General's office and the lawyers of that office. Perhaps I've done something, but I don't remember having signed something. Perhaps I signed a report that was supplementary to a pleading, but I didn't write the pleadings.
9 of your first report, you say, specifically, my written professional work on both cases entailed submitting oral and/or written arguments at the appellate and cassation stages of the proceedings before the chambers of the Superior Court and Supreme Court that heard and resolved these cases. Does that refresh your recollection?
Well, what do we understand by written reports? That's the problem. Perhaps there were written reports for the legal team justifying a certain position, and some writings that were presented on appeal, and those were submitted by SUNAT without my signature. They were the responsibility of the Attorney General and the Attorney General's lawyers. Now, when we talk about written arguments before the tribunal, I don't remember. I really do not remember. My role was coordinating internal strategy, preparing reports, and oral reports.
You were arguing in the oral hearings before the Supreme Court in both cases, is that right?
Sí, es verdad.
That is true, yes.
And you made those arguments on behalf of Sunat, right?
Yes. Next to the Attorney General of Sunat that dealt with tax matters, I looked at the constitutional side of things. For example, in the case of Cerro Verde, the debate on the nature of the contrato ley and everything else, that was my doing. That was my part, so to speak.
And you also represented Sunat in the oral arguments before the two appellate courts in the 2006-07 and the 2008 royalty cases, right?
Of course.
And I recall you told us you had a success fee arrangement for those cases and the series of other cases in which you represented Sunat. Is that your recollection?
Yes. Would you want me to explain that, or yes is enough?
Let me ask you a question. After Sunat prevailed before the Supreme Court in the 2008 case and prevailed ultimately before the appellate court in the 2006-07 case, you received a corresponding success fee payment, right?
Yes, as indicated and agreed upon in the contracts that were entered into, this success fee would occur, one, if the case was won, and two, there was a percentage on the amount obtained. And this would only occur not only after the end of the proceedings at the Supreme Court level, but also if the decision became fully enforceable. This is public information. The collection was going to be on the basis of the percentage stipulated in the contract.
You also represented a number of other investors. You also represented Sunat in contentious administrative proceedings before the Peruvian courts brought by a number of other investors. Is that right?
Yes, mainly by Telefonica. There was a bank. There was also an oil company.
I think you testified that you represented Sunat in 16 contentious administrative cases that were being brought by Telefonica. Is that your recollection?
Strictly speaking, I had 5 contracts with Sunat that started being enforced in 2016. Out of those 5, the more voluminous, so to speak, was the Telefonica one that had 13 cases. Out of the 25 cases, 22 had been fully decided. Out of those 22, we fully won, or majorly won, 18. And in the case of Telefonica, out of the 13 Telefonica cases, 12 have ended. We fully won, or majorly won 10 and lost 2.
So in the Telefonica cases, Sunat won 10 cases and lost 2 cases. Is that right, approximately?
No.
The question or the answer?
Your question, sir, I heard 1 10 cases and lost.
Okay, let me repeat it. So in the Telefonica cases, Sunat won 10 cases and lost 2 cases before the contentious administrative courts, right?
Yes, perhaps 8 or 10. I don't know if it fully won or fully lost.
And you also represented Scotiabank in contentious administrative cases on behalf of Sunat, right?
I don't know what you mean by represent. I have been emphatic when I said that I do not represent. I have never represented Sunat. Sunat is represented by a single Attorney General. He is a public official. I have participated in the defense as a lawyer. I participated together with Sunat in 2, I think, actions brought by Scotiabank. There was an amparo and there was an administrative case, and both decisions were favorable to Sunat.
So you also appeared on behalf of Sunat, maybe that's a better word than represent. You appeared on behalf of Sunat in contentious administrative cases that were brought by a company called Sabia. Do you recall those?
Yes, I do recall. The contract has 2 cases. In both cases, the claimant is Sabia. Those cases concluded a long time ago, and the claimants were dismissed, and there were 2 amparos that Sunat brought against Sabia, and those are quite delayed, and they're still pending.
The 2 Sabia cases that were concluded, Sunat prevailed on those 2 cases, correct?
Yes.
Sí.
So, at the minimum, in the cases in which you appear on behalf of Sunat, Sunat seems to have a crushing success rate. If I counted them, there were like approximately, 25 proceedings and 23 wins, approximately. I may have gotten the math wrong, but it was an overwhelming success rate of Sunat, wasn't it?
Well, it's not 23 successes, 19, 18, that's the number of successes. It is a success rate, yes. Give me a little bit of merit. I think I have to be shown some credit.
Mr. Aguiguren, you also stated, in addition to having appeared in the defense of Sunat in those cases that we just discussed, you also periodically advise MINEM and the Ministry of Economy and Finance, right?
In my CV, I made reference to state agencies, just in case, for you to know this. And I have provided advice periodically or sporadically to these agencies. I didn't have specific contracts. MINEM and the Central Bank, the Superintendents of Bank and Insurance, and MINEM as well, a long time ago. But this had nothing to do with issues like this. And other public agencies, I included this in my CV because I wanted to talk about sporadic professional contracts I had with state agencies.
And Mr. Aguirre, you also told us at the SMM hearing that you periodically provided advice to Sunat. Is that correct?
Yes. Before making these contracts, I had prepared some specific reports for Sunat at the beginning of this century. Specific things, yes.
And this is not the first time you appear as an expert in exit proceedings. I think you were retained by the Republic of Peru as an expert in, I think, a total of 4 exit cases, right?
perhaps 5. We can go further back in time. There's one which is Awaitia Energy.
Pasa que
But I only provided a written report in that case. My first hearing, well, in the Bear Creek case, for example, I didn't come to a hearing either. In the Leader Con case, that was my first appearance, and then, of course, in these 2 cases, Freeport and SMM.
I have to correct myself now that I read paragraph 6 of your first statement. You appear not to have been appeared as an expert. You say you were responsible for the Peruvian state's defense. Is that correct? Put it on the screen. That would be paragraph 6 of your first expert report.
In Spanish it says expert, eh?
In Spanish, it's expert, so, well, I didn't translate it.
And just to be clear for the record, the Spanish is the original document.
Well, yeah, it's a Freudian translation slip, perhaps. So your testimony is that you were retained as an expert in those 4 cases on behalf of the Republic. 5 cases, you said. Yeah, if you count this case, we come to 5. So your testimony is that you were retained as an expert by the Republic of Peru in those 5 exit cases. Is that correct?
Technically, I was hired by Sidley. They have a relationship with the state of Peru. Now, where the resources come from, I don't know. I was retained as an expert.
Professor, you haven't yet been retained as an expert by an investor in an exit proceeding. Is that correct?
Not yet, no.
Espero.
I hope.
I reviewed your CV. It's fair to say that you have focused your career on constitutional law and human rights law, correct?
Yes. Constitutional law, that's a very broad subject, right?
But you would not hold yourself out as a mining law expert, would you?
Never.
And it's also fair to say that you haven't taught mining law, right?
No. There is an undergrad and a postgrad seminar that I teach, and we have cases that we look at, and amongst those cases, I deal with stability agreements, and one of those cases has to do with Cerro Verde.
And you also have not published on mining law, right?
I have not. A while ago, I published in the Gaceta Jurídica work that had to do with contratos ley and the constitutional scope of freedom of contract. I can tell you that in connection with freedom of contract, I have published a chapter in a book, and the publishing house was Gaceta Jurídica, but only about contratos ley and not about the others.
About Cerro Verde stability agreements.
He's going to have to repeat that. I'm sorry.
Yes. I wanted to ask you a question. You mentioned earlier today Cerro Verde stability agreements. And I wanted to ask you a question regarding the 1994 and 1998 stability agreements. Do you know the difference between a 10-year stability agreement and a 15-year stability agreement?
Yes. But if the hypothetical is that the investment that is guaranteed is not only the one that's in the contract, but in future investments in the contract, the protection exists from the very first contract if the concessions are the same.
Professor, can you tell us the difference between a 10 and a 15-year stability agreement, other than the obvious one, which is that one lasts 5 years longer than the other?
Yes, that as per Title IX of the General Law in Mining, which regulates special guarantees and assurances, it has to do with the amount of the investment, for example, that is made. The objective that in respect of, say, expanding output. The lengthier agreement, 15 years, means a larger investment and a more ambitious objective.
Let me be a bit more specific. What additional benefits does a 15-year stability agreement give you that a 10-year stability agreement does not have? Why would a mining company want to have a 15-year stability agreement, other than it extends stability by 5 years? What are the additional benefits that the mining law grants if you hold a 15-year stability agreement?
I would tell you that I would consult I've looked at the 98 contract. I'm not a specialist in all the modalities, but I would tell you to consult a specialist in mining. I'm not that.
So, Professor Aguiguren, you're telling us that you testify in your expert report, and again here in the opening, about the 94 and the 98 stability agreement and why Cerro Verde would have concluded both without having analyzed what the difference is and why a mining company may want to conclude a 15-year stability agreement. Is that your testimony?
No, I don't think so. From what I recall, both pertain to concessions 1, 2, and 3 of Cerro Verde. And if the hypothesis that the claimant has been putting forward is that the investments in a given concession are not just the ones that are in the agreement, but also future ones are what is protected, then of course the duration and the amount are going to be different. Perhaps what I would wonder is why was that expanded, or why is there not a new agreement? But my legal argument is to say that every time there's been a major investment, a new agreement was sought. Now, if every investment was covered, yes, there was a difference of some years, but the stability guarantees, well, now I'm not a specialist in the different types of mining agreements. I've analyzed the 98 agreement.
Before reaching that conclusion, Professor Aguiguren, have you reviewed correspondence between Cerro Verde and Minim regarding the relationship between the 94 and the 98 stability agreement?
I've read what's been put forward in this proceeding, but not in detail, because that wasn't part of the analysis that was entrusted to me. I've not given any opinion on facts, nor have I analyzed those matters. I have analyzed the agreement.
And did you know that Cerro Verde applied the 1998 stability agreement to all of its entire mining unit since the 1st of January 1994? 1999, pardon.
No, I did not know that. Because it's not in the agreement.
Mr. Aguiguren, you testified, though you say you're not a mining law expert, you testified about the scope of Article 83 of the mining law, don't you?
I don't recall. Article 83 of the law?
Of the law.
83.
83. I'm sorry, but I heard 3. Yes, I have interpreted it. And I note that especially in its 4th paragraph, it raises the need and the requirement that the guarantee or the benefit granted has to do with the feasibility study, which is where the investment project is described.
And I did not see in your expert report when you describe the scope of the stability benefits a reference to Articles 2 and 22 of the mining regulation. Is there any particular reason you did not consider those?
I believe I made some response, or some reference rather, in my reply report because Ms. Vega referred to them, calling into question my position. The thing is that it's likely that I made a very specific reference because I reiterate my analysis is based on the contratos ley as set out in the Constitution. That's the supreme law. The statutes can't go beyond the Constitution. And then the mining law. Now, the thing is that the same provisions are read differently by the parties. As I see it, Article 22 of the regulation of Title IX confirms, like the 4th paragraph of Article 83, confirm that stability and the benefit of the guarantee is granted specifically with respect to the investment project contained in the feasibility study that's incorporated in the agreement. Now, regarding those same provisions, the claimant and its experts interpret that they cover any present-day or future investment on the same concessions. These are different interpretations, apparently irreconcilable as between the parties on this issue, but the difference, and favoring my interpretation, one can invoke a judgment on cassation by the Supreme Court. Profesor Eguiguren, cuando usted indicó su posición en su...
Professor Eguiguren, when you stated your position in paragraph 38 that the effect of the guarantees are limited to an investment project, what you did is you repeated the position you took as Sunat's defense counsel in all of those proceedings, but you did not make an independent analysis that considered Articles 2 and 22 of the mining regulations, did you?
That's likely.
And did you, coming to that conclusion, did you analyze decisions that have been made by the DGM or by the Mining Council with regard to scope of stability agreements? Sorry.
No, I base myself on the decisions of the tax tribunal and judicial decisions. It's like in the previous case. I don't place all that much emphasis on the regulation because the regulation is subordinate to the law, and it cannot go against the law. And so interpretations of the regulation that are contrary to the law would be mistaken. They'd be considered illegal, unconstitutional. The same happens here. There may be opinions and such. I'm not an expert in mining, so therefore the work of the Mining Council is not something I've looked at, nor the Directorate General for Mining. No, because I analyze a contract, and on that I look at what the tax tribunal has said in its decisions and what the judicial branch has said, and those are higher-ranking instances.
Eguiguren, did you review and consider decisions by Sunat regarding the application of stability agreements when before you reached that conclusion?
You mean generally speaking?
reach that conclusion that you put into paragraph 38 of your first expert report?
Now, as I have said, in my participation in cases involving Sunat and Cerro Verde, well, that began in 2016, 2017. Obviously, in that case, I reviewed, for example, and then, of course, with this arbitration of the previous one, before writing my report, I reviewed the reference to the reports by Mr. Isasi of the Ministry of Energy and Mines, who, going back to 2005-2006, was already saying that the primary sulfides project wasn't protected, the statements by the Minister of Energy and Mines, and the Sunat assessment. And I read internal Sunat reports that, more from a tax perspective, explained the position in that regard. Now, all the prior history, no, because for my legal analysis, it wasn't necessary.
So that's what you base your conclusions on, Mr. Isasi's report, Mr. Isasi's June 2006 report. That's the sort. That's what you base your conclusion on.
No. I base my conclusions on my analysis as a professor of constitutional law regarding the scope of contratos ley and mining stability agreements and the 98 agreement. And now what Mr. Isasi and other witnesses have said, it corroborate my interpretation, but no doubt my analysis is a different one. Not different in content, but it's my own analysis. It would have been more complicated for me if the meaning were different, but that wasn't the case.
Well, Professor Gigurin, you said you're not a mining law expert. You did not look at the decisions of the Mining Council. So what else did you look at other than Mr. Isasi's report? It was just Mr. Isasi's report and your own reading of the mining law. Did I understand that correctly?
For this arbitration and the previous one, I have also read witness statements. But the truth is, well, my first report, if you know my reports well, is a report of legal analysis of the Constitution and the law. You're not going to find in either of my two reports references to what Mr. Apollo may have said, what Ms. Chapuis would have said. Yes, I do recall that I made a specific reference to Isasi's report, but very much in passing, because those are facts. And I'm analyzing the 98 agreement. It would be different for me were there an opinion of the state that had said, yes, the primary sulfides plant is protected. That would have required that I undertake a different type of analysis, or it would have created a different kind of doubt. But I haven't seen in the claim or in the reports of experts anything on that, other than said, suggested, proposed. So I don't claim to do what I haven't done, but you're familiar with my two reports and you know their scope.
Would it be a good time for a break?
Yes, it would be a good time. Thank you very much.
Then we meet again at 4.
Puedo ir a tomar un café, ¿no?
Can I go to take a coffee?
Yeah, I mean, look, I'm sure they're roaming around the building. I see, got it. Gotcha. Got it, right. Yeah, no, nobody that I can persuade to do that. Sorry. I mean, yeah.
Professor Aguirre. Let's talk about Article 86 of the mining law that you had already mentioned. You will recall that it provides that stability agreements are adhesion contracts that incorporate all the guarantees established in the mining law. Is that correct?
That is correct. They include articles or the guarantees mainly of the mining law and the feasibility study.
Let's take this apart. You would agree that the content of the mining stability agreement is predetermined under the mining law and regulations, right?
As I said before, that is correct. Part of the contract comes from the law. The law, mainly.
Well, in your first witness statement on paragraph 41, you said plainly the content of the agreement is predetermined under the mining law. Is there any reason you want to change that?
No, I don't need to change anything. I am just being specific. The content, part of the contract is predetermined by the law and it is non-negotiable, but many other parts of the contract will come from the feasibility study that was presented by the company. In part, I would need to look at everything, but I think that the report in its conclusions and as a whole do not support that everything is determined in the law.
Well, let's look at it a bit more precisely. The mining law provides for certain stability guarantees, right? So the parties can negotiate more stability guarantees than those provided in the law or less stability guarantees than those provided in the law, right?
I didn't understand the last concept, but the guarantees are non-negotiable. They are provided for under the law. The duration and the subject matter.
Right. Then the mining law also provides for a certain duration of the mining stability agreement. It says mining stability agreements either have 10 years or they have 15 years. So the parties can't sit down and negotiate to have a 12-year stability agreement or an 18-year stability agreement, right?
I do not think so. It would depend on the type of contract. Now, I am not an expert. I said that before in mining. I do not discard what I do not know, but it could be that for some reason the duration is lower, maybe higher, it's impossible, but honestly I do not know. I would need to look at the characteristics of the investment, etc. The law establishes a parameter that cannot be granted, that you cannot grant more guarantees on other requirements or other benefits.
If we're able to negotiate a shorter term, like 12 years or 8 years, how would that square with the non-discrimination and the non-discretion that you outlined as guiding principles for the model agreement when you gave your opening presentation?
No, yo no.
I do not know. I have not said that they can do that. I do not know. But what I said is that, let's see, the guarantee is a benefit. And that's why I said that it is an exceptional regime. If for some reason the investor would like to have less, there is no discrimination. But the problem would be if they receive more than others. I don't even know if it is possible. I don't know whether there are cases in which they accept a shorter period. You should not forget that according to the mining law and the contrato ley, the investor may waive a benefit, may waive a term if tomorrow the law would change and would grant better benefit than the one under the contract. In my understanding, the investor can choose that benefit. The problem is you cannot give someone more than you give someone else, because that would be discrimination.
Can you tell me about a stability agreement that's not a 10-year or 15-year stability agreement, Professor? Can you mention me an example?
I do not know. I doubt it.
And the mining law also defines the scope of the stability agreements. You mentioned Article 83.3. So you would agree that the parties cannot also negotiate a different scope for a stability agreement than the one that's set forth in the mining law, right?
¿Respecto a qué?
In connection with what?
Scope of the stability agreement, to what the stability agreement applies. The scope, el alcance.
That is correct.
Well, let me just ask you. So, under your premise, the scope of the stability agreement, your premise, which you have developed as advocate for SUNAT, the stability agreement applies to investment projects. So the parties cannot go and reach an agreement and say, well, we want the stability benefits applied to a mining unit, right?
No, si no está.
No, if the investment is not in connection with that concession and there is no new investment, the contract, for example, the 1998 contract specifies at clause 1.1, 2, 3, that the investment as such for the leaching project, what concessions it is limited to. It cannot be expanded to others unless the contract is modified.
Our premise, if the tribunal concluded that the mining law said that the scope of the stability benefits extends to concessional mining units, then the parties could not negotiate a different scope than that because they have to comply with the law, right?
I didn't understand the question very well by making reference to the tribunal. Is this tribunal or a different tribunal, a Peruvian? I didn't understand the reference to the tribunal and negotiation of the parties.
Hypothetical. I mean, you said, under your premise, Article 83 says that the scope of stability agreements applies to an investment project, and hence the parties cannot then negotiate something different. They cannot say, oh, I want it to apply to a mining unit, or I want the scope to apply for something different. Let's take another premise, another hypothetical. If the mining law said that the stability guarantees apply to a concession or a mining unit, not to an investment project, but to a concession or mining unit, the parties could then not negotiate something different. The scope would be set by the mining law, right?
If the law provided for that, yes, but then it would not all in all be a guarantee for an investment in particular. I think that the rationale behind this contract is to have specific investments.
Understood. That's your position as SUNAT advocate, but I think you answered my question. Do we have anything else? I don't have any further questions then. Thank you very much, Professor.
Any questions in record?
Could I take 3 minutes, please?
Sigue siendo un gusto haberlo vuelto a ver.
May I? Thank you.
Doctora Eguiguren, le preguntaron sobre sus representaciones de la SUNAT y si vamos. Of course. Doctora Eguiguren, le preguntaron sobre sus representaciones de SUNAT en
We're not getting any English interpretation, please.
No.
Can one of the interpreters test the English?
Testing now? Testing, testing? Yes? Okay. Okay. Okay, thank you.
Yes.
Dr. Eguiguren, you were asked about the advisory services you provided to SUNAT, and in your resume you have included in your first report as Exhibit A, you established that you are an advisor and consultant for state bodies and private companies. Would you please explain? Yes. As stated here, my main professional experience because of public law and constitutional law has been requested mostly by public entities, but sometimes it is for private companies. In my resume, as in my previous arbitration, I included everything that is related to state companies. I have not referred to private companies, whether there could be any interference because of mainly I work with SUNAT, but I have provided reports also for various private companies sometimes, even if you allow me, with the Rodrigo law firm as an external consultation for companies on constitutional and administrative issues. I have done that, but I didn't include it. Thank you.
I have just one remaining question. In the course of today, we heard Mr. Boulard and you testifying on the same question, and the two of you came to clearly opposite results. And I want to understand the position you took today a little bit better. I understood Mr. Boulard testifying today that because the stability agreements are adhesion contracts, what matters is its Exhibit 1 and its reference to the beneficiation concession, regardless of the time and scope of the beneficiation concession on the date of the stability agreement. So a future extension, like we had it here for the concentrator, would bring the concentrator under the protection of the stability agreement. I understand you testifying no. An extension of the beneficiation concession retroactively can by no means extend the scope of the stability agreement, never. Did I understand you correctly that you categorically denied the proposition that Mr. Boulard took this morning?
Yes, I say categorically no as to granting an exceptional benefit in a retroactive fashion. Now, if it was possible for the concentrator to be included, I know that technically, and I am not an expert, this is leaching. Leaching and concentrator are two different things from the technical point of view, but Article 3 under the contract allows to make expansions and additions to this. And if this was the case, or if a new contract was entered into in connection with the concentrator, it would have the benefit as of the time of entering into the contract. But that did not happen. And it did not happen. And that's the reason why we have this case.
Thank you. So we have no further questions. Thank you very much. You're released as an expert in these proceedings.
Muchas gracias. Muchas gracias.
I thank you. I thank you very much.
You with the next expert. This is Mr. Morales. Let us know when you're ready.
Agua, ¿no? Listo. It's in informe. It's in that. It's in chapter. Ah, yeah, yeah.
Are we ready to start? So, welcome, Mr. Morales. Good afternoon.
Buenas tardes.
You have been
Good afternoon.
nominated as an expert in this arbitration by the respondent. I introduce us as a tribunal. I'm sitting here with Professor Tawil and Dr. Cremades. Myself, my name is Inka Hanefeld. I'm the presiding arbitrator in this arbitration. And I kindly request you to read out the declaration that you should have in front of you.
I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you. And do you also have your expert reports, RER 2 and 7, in front of you?
Yes. Sí, efectivamente están mis informes.
Yes, indeed, I can see my reports of May 4th, 2022 and November 3rd, 2022. And I recognize that these are my reports and also that I have drafted them.
Presentation, I understand that you will now have a presentation. Please, go ahead.
Buenas tardes, miembro del tribunal.
Good afternoon, members of the tribunal. Greetings to council and also ICSID staff. My name is Ronaldo Morales Herbias, and I will sum up the situation, but before that, I will be express some very specific points before going into the 5 parts of my presentation. I am a civil law professor for 22 years at the Pontificia University of Peru. I have, among other institutions, such as the University of San Marcos, I have 25 years of professional experience. I am also an author of different books and essays on various aspects of civil law, and I am also an arbitrator at the Arbitral Center of Peru. The interpretation of the mining law, its regulations, or the political constitution is done following the principles and categories of Peruvian law. Peru's 2008 Supreme Court judgment constitutes res judicata with respect to that subject matter discussing such proceeding, but this judgment has an interpretative value in connection with the mining law and the stabilization agreement. I will address 5 parts. First, I have some introductory comments. The experts have already received to the nature of the stability contracts, and Dr. Uiguren has also explained that. Then I am going to refer to the stabilization agreement, and I am going to focus on the binding interpretative rules for any tribunal analyzing this type of contract. Next, I will be referring to the Supreme Court judgment that ratifies my thinking, and this is a judgment of 2007, and then I am going to refer to the absence of contract compliance, and then conclusions. First, introduction. As to the nature of the stability contracts, there is a debate in Peru as to the nature of the contratos ley, and in Peru in particular, as I mentioned in my 2 reports, is that they are of a mixed legal nature, not only because there is administrative and civil law doctrine and scholarly work that analyzes this, but before then, the 1984 code had already analyzed this. The contratos ley contain benefits in favor of individuals that the state can only grant by law, because given their content, they should be qualified as administrative contracts or agreements. On the other hand, the state is deprived of the jus imperium that characterizes the regime of administrative agreements. Therefore, contratos leys have a dual character. They are agreements that are negotiated and entered into in accordance with the rules of public law, administrative law, but which are implemented under private law or civil law. Something central to this is whether the stability contracts are not adhesion contracts. I argue that they are not ordinary adhesion contracts, and I refer to comparative scholarly work as to what has to be complied with the adhesion contract. There is no pre-negotiation or negotiation stage, that the content of the contract is drafted or prepared by one of the contracting parties, that the other contracting party adheres completely to the content of the contract, and the 4th characteristic is that the adhering contracting party has a weak bargaining power. In this case, one 2 and 4 are not met. Therefore, the purpose of the contract, which we are analyzing in this case, is to stabilize the investment project as described under the feasibility contract. The purpose is not adhesion, and it is the investor, the one that proposes the feasibility study. We here see a lot of blank spaces, or the form has blank spaces for the mining company to include it, taken from the feasibility study. This comes from Article 85 and 19 that refer to the feasibility study. The general mining law and its regulations define the guarantees granted to investors, but not the subject matter of the stabilization agreement. The investors define the subject matter of the stabilization agreement through the technical economic feasibility study. It wouldn't make any sense for the model contract to have left so many blank spaces for the parties to include a description of the investment project, or for Article 19 of the regulations to include so many requirements to be met by the technical economic feasibility study. And it would make no sense to interpret the stabilization agreement if the stability guarantees were only defined in the general mining law. This is important to mention. The Supreme Court has confirmed in their 2017 judgment on the royalties case the interpretation of the contract. The Supreme Court interpreted the contract and whether it breached or not the mining law, and this is something that we're going to see. The Supreme Court acted as an appellate court, and an appellate court in our civil law countries acts as a court to determine whether a contract breached the law or not. So the Supreme Court of Justice, the highest court in Peru, determined whether this contract breached the mining law or not. The second portion of this will be focusing on the stability contract agreement that did not comply the concentrator or the primary sulfate plant. Before I focus on the other portions, I will focus on interpretation. In Peru, there are 6 rules of interpretation: the literal interpretation of the contract, the systematic interpretation of the contract, the global interpretation, that is to say the conduct of the parties, the interpretation in accordance with good faith, and functional interpretation, and contra preferentum interpretation, that is to say the clauses, for example, those contracts that have adhesion clauses have to be interpreted in favor of the weaker of the two parties, that is to say the vulnerable party under the contract. And in my specific opinion, this interpretation is not to be applied in this case. Why? Because the national doctrine of Peru, whenever indicating this, they have indicated that this interpretation to begin with is ancillary. So a contra preferentum interpretation implies that I first need to resort to the 5 other ways of interpretation: literal, systematic, global, and functional, and in good faith, to see if I can apply this one. And also the national scholarly writings show us that there has to be ambiguity to apply this contra preferentum interpretation. And I am going to show that there is no ambiguity. The purpose of this contract is the feasibility study, and here we have seen that it is the concessions and the mining rights are the most important. No. And as the contract says, the investment project, the plan, are the most important aspects.
This is the basis so that the mining title holder can have an agreement, a stability agreement. Without an investment project, there is nothing. The title holder of the mining activity can have 100 concessions, but if it has no investment project, no benefits or guarantees under the mining law or the Constitution will be granted to him. I'm going to explain very briefly these rules of interpretation. The literal interpretation is the privileged one. Article 168 of the Code is very clear. The clauses are to be interpreted according to what has been expressed in the contract, according to what the parties have said. Here at slide 13 talks about the later interpretation of clauses 1, 3, and 4 of the Stabilization Agreement allows us to assert that the common intent of the parties was that the contractual stability guarantees would apply exclusively to the investment project included in the feasibility study. Another important interpretation is the systematic interpretation. What has the scholastic opinion said about this? That the relevant clauses have to be interpreted in connection with those clauses that are connected. My colleague and friend, Mr. Bullard, said something that I disagree with, and this idea doesn't come out of clauses 1 to 8. If you do a systematic interpretation of clauses 1 to 8, what we can see is that to be a beneficiary of the contractual guarantees, you need an investment project that needs to be approved by the mining authority. So without an investment project, you can be the title holder of 1,000 concessions. Without an investment project, you're not going to have the exceptional benefit provided to you and the investors by the Constitution. The government says, okay, I'm going to place you in a situation of immunity. You're going to have exchange guarantees, guarantees where the law will not change. But in consideration of that, you have to submit an investment project that's going to be approved by the government. This is important, and I will talk about the contra preferente interpretation soon. Mr. Bullard talked about clauses 9 and 10 because they are irrelevant. But the Supreme Court said that clauses 9 and 10 make no sense to provide any kind of interpretation or provide some kind of extension to an investment project. Clause 9 clearly states the contractual benefits. Clause 9 talks about the contractual benefits. And Clause 10 says that later laws cannot be modifying what was already approved in the stability, in the feasibility study. So these are irrelevant, really, for this discussion. The 98 Stability Agreement does not mention at all the primary sulfides project. To the contrary, it mentions 10 times the Cerro Verde leaching project. It's a literal interpretation of the contract. Another important interpretation that I think is fundamental and we need to mention here at 23, for example, you can see the language of the Supreme Court ruling at paragraph 35 that says that the 9th and 10th clauses of the agreement do not render the above ineffective, inasmuch as said clause 9 only outlines the benefits that will be enjoyed by the claimant in relation to the investment in its concession. And then clause 9 talks about the legal provisions after the approval of the feasibility study. Those are not going to affect the stability agreement. Clearly, the court has taken a position in connection number 9. It says that clauses 9 and 10 do not help us settle the controversy. This is a 2017 judgment. There was no scholastic opinion, expert mining opinion, or a thesis or an article in this ruling. this was published in the official Gazette, and everybody can read it and to criticize it. And this is something that the Constitution says, and anybody can criticize the judgment, but no legal scholar has made reference to this in 2017. What about good faith? What does it mean in interpretation? Well, the interpreter of a contract has to apply the standard of an average reasonable man. The interpreter must place two reasonable persons in the shoes of the contracting parties, asking them how they would have understood what is stated in the contract and how they would have complied with it in a similar case. So an average reasonable man would have interpreted that the guarantees of the stabilization agreement of SMCV reasonably extend to the investment plan of the Cerro Verde leaching project according to the technical economic feasibility study. This is a functional interpretation, right? What is it? Well, you have to interpret your clauses according to their purpose and to the intent of the parties. And here we're talking about a functional interpretation of the stability agreement. What is the functional interpretation of this agreement? Well, to grant the stability benefit, but in connection with the leaching project, paragraph 36 of the Supreme Court judgment is important. That it says that the investment includes the feasibility study and that the investment plan covers it, and they only extend to the scope of the benefits arising from the stability agreement. The Supreme Court, at paragraph 36 of the decision, defines the purpose of the stability agreement. You also have global interpretation. You're trying to interpret the conduct of the parties. Mr. Bullard talked about 7 different conducts by the Peruvian state that would have created reasonable reliance in the mining society that the concentrator was included in the agreement. But in other conducts of the parties mentioned by Dr. Bullard, it is verified that after the execution of the agreement, there was an agreement by both parties that the contractual stability guarantees were included in the concentrator plant. Mention was made that it's not implicit in the stability agreement. Clause 14 of the stability agreement clearly says to amend this contract, you need an agreement and a public deed before a notary. Is there a contractual agreement formalized by a notary that includes the concentrator or the primary sulfides project in this stability agreement? No, none. There is no addendum, there is no agreement, none. Clause 14 is very clear in the stability agreement. There has to be an agreement. One cannot say, okay, I think that this is what it says. No. There has to be express agreement that that primary sulfides project is included in this stability agreement. Without that, then you would be violated the contract if you resorted to that interpretation. That is why the Supreme Court said that the primary sulfides project is not included in the stability agreement. And I think this portion, number 3, is very important. It has to do with the Supreme Court judgment of 2017. I said that in Peru there are 6 ways to interpret documents. These are interpretive rules that any lawyer, law student, or judge must resort to justify his or her assertions and final decisions, specifically. The literal interpretation, the systematic interpretation, the global interpretation, the functional interpretation, and the interpretation based on good faith. And then there's a 6th one, which is known as the contra preferentum interpretation. The court, in paragraph 36 of its judgment, addressed this. There is no ambiguity in the Stability Agreement of 1998, where you can say, okay, here it talks about the sulfides project. Over here they talk about the leaching project. And over here they talk about the concentrator plant. And this other talks about something else. No, there is no ambiguity. To apply 1401 of the Civil Code of Peru to interpret the clause in favor of the adhering party, then the contractual party has to be vulnerable. Why? Because that party has not negotiated the contract. It has submitted itself to the adhesion contract. Here, the investor has proposed the purpose of the contract, which is the feasibility agreement. How can you say that this is a vulnerable, weak party? Ambiguity. Where is there ambiguity in the stability agreement? No mention is made in the contract at all of the concentrator or the primary sulfides project. It mentions 10 times, however, the Cerro Verde leaching project. The court uses 3 interpretation criteria of paragraph 170. It's mentioned here: literal interpretation, systematic interpretation, and interpretation based on good faith. And this is critical. It says the contractual benefits that result from the stability agreement are not as broadly enjoyed as the appellant has suggested, which is why it is impossible to reach the conclusion that the benefit extends to every investment the mining company makes in the concession that is the subject matter of the stability agreement. What claimant and the experts do is look at adhesion contract from a very broad viewpoint. The law talks about adhesion contract only in connection with guarantees. They are immutable. That is what it refers to. Well, if we talk about disc, we can talk about vinyl, we can talk about a CD, but what is a disc? Okay, they're talking about adhesion, right, but you have to interpret what adhesion is. A company like SMCV, is it a vulnerable party? Definitely not. Okay, an adhesion contract, right? And you have to interpret the contract. You are members of the tribunal, and you are going to interpret what adhesion means. But the Supreme Court has done so at paragraph 36 of the judgment. I wanted to underscore that I think it's important to share with you this idea. Here I compare the interpretations that I've mentioned of the different clauses, and I have put here the paragraphs of the Supreme Court. You yourselves can see at your office by yourselves whether there is a coincidence between the stability agreement contract clauses and what the Supreme Court has determined in that connection. Why is this judgment important? Well, it's important for the parties because it deals with the royalties case of 2008. The interpretation of the Supreme Court has not been contradicted by any court whatsoever. There has been no national scholastic opinion that has criticized this ruling. Well, maybe there were opinions, but they were just opinions. Those opinions were not issued by a Supreme Court justice. In our system and in other legal systems, well, we do have to respect the decisions of the Supreme Court. And the Supreme Court here has interpreted the stability agreement as to whether there has been a violation by the mining law or by the regulations. If you seek to interpret this, you cannot ignore these things. It is not useful, like Mr. Bullard said, for a Supreme Court justice to exist. What is it that means? Of course, a Supreme Court ruling is useful. Here, the Supreme Court has interpreted something. So, weren't they competent? Didn't they have authority to interpret a mining contract, even though they were perhaps not experts in mining law? No, of course, they're justices of the court. You can question the decision, but the facts are there, and the interpretation made by the Supreme Court has been given. So, I think that there is no reason for the stability contract to be interpreted otherwise. The Supreme Court has decided via cassation as a court of last resort. Cassation, what does it mean? Well, it means that there's going to be an annulment of a ruling. And on Article 384 of the Civil Code looks for the proper application of the law and the interpretation of objective law. And Article 400 of the Code of Civil Procedure says that these cassation justices are mandatorily published in the official gazette. Whether we like it or not, we have to abide by the interpretation by the Supreme Court. What the Supreme Court has done ultimately is to examine the 98 agreement, and it has looked at whether this contract applied to other projects, or in this case, the primary sulfides projects. But first, the court had to see whether the contract had breached the law, had breached the mining regulations, but the Supreme Court also had to interpret it, to interpret the contract. And he has used literal, systematic, and good faith interpretation as methods. So the use of these interpretation rules has not been questioned. The Supreme Court has interpreted the mining law and the stability agreement. That has to be respected. That decision has to be respected. You can call it into question. Fine. Of course, you can criticize things, but you cannot modify this unless you interpret the law in a different manner. I am a contract law specialist, and I cannot see how anyone can say otherwise. If you would like to interpret this differently, and this is what claimant is trying to do, if you're trying to say, okay, no, this contract has to be interpreted only under the contra pro ferente method. First, there has to be a weak party, and second, the clauses have to be ambiguous. No, this is not the case here. The provisions are very clear, as I have stated in my reports. And I think something else that's important has to do with the breaching of the stabilization agreement. I was very surprised by the example by Mr. Bolar in connection with the lease agreement. For example, if you have a tenant that does not pay a number of rent payments, then, okay, I would have to sue that person for that. But I have to say that the state was not obliged to apply the stabilized legal regime to the concentrator plants since the stabilization agreement granted tax currency exchange and administrative stability benefits only to the leaching project. And this is my conclusion using the interpretive rules that I have mentioned. Consequently, SUNAT did not breach the stabilization agreement when it issued the assessment related to the payment of taxes and administrative charges related to the activities of the concentrator. Now, hypothetically, what would have happened if Peru had breached the assessments under the stability agreement? The alleged breach of the agreement occurred when SUNAT notified SMCV of the assessments. Note, this is very important. Assessments are administrative acts, and according to the General Procedures Law, administrative acts have efficacy and are enforceable ever since the regulated party is notified. There is also a very important principle, the validity of administrative acts. Administrative acts are considered valid unless they are annulled or their efficacy disappears because of the decision of a judicial or administrative court. But ever since the regulated party receives notice, then if there is a breach, that breach ceases to exist at that point in time. Then the economic loss resulting from the alleged breach materialize with those notifications. Mr. Boulard says that if the lessor doesn't pay the first, second, or third month of rent, well, it could mean that the damage would exist if there are future breaches of the lease agreement. With the first breach by the tenant, then the tenant has violated the contract. And then, according to the Peruvian law, you can ask for compensation for specific performance, or perhaps the lessor didn't pay for, rather the lessee didn't pay for 12 months. And I'm not going to have 12 suits. Just one suit is enough. Here, I talk about the alleged breach from a single cause. The first notice of the assessment, that is a breach of the contract. If there were other assessments referred to different amounts, referred to different fiscal years, well, that's a different thing. But hypothetically, if there is just one breach, that's enough. That is why I bring here the example of Mr. Bullard, because in Peru, that case and this case is SMCV. Well, SMCV should have considered that the first administrative act of assessments was notified to it. Well, the act was presumed valid, and therefore I can submit an action for contract breach. I don't know how I'm doing time-wise, but
Interrupt you, but
Sí.
now your time is almost used up. So if you could come to an end, this would be great.
Yes, Madam President, 5 minutes, 27 minutes, it says here. So I have divided assessment in two phases, substantive and procedural. Mr. Bullard only looked at the procedural phase. I think that if there was a contract breach by the public administration, that has to do with the first notice. And if there are more notices after that, well, that's something that needs to become cumulative. So you have to look at the different assessments that took place in this case. What I say here is that under Peruvian law, assessments do not have to be final, definitive, and enforceable acts, like Mr. Bullard said. In Peru, contractual responsibility has a statute of limitations of 10 years. The provision is very clear. It is Article 1993 of the Peruvian Civil Code that says that the statute of limitation begins to run with the possibility of initiating the action. When is it that Peru breached the contract? Well, when the first assessment was notified.
Way above the time limit already. It doesn't sound like a concluding remark.
Where do we stand?
32 minutes.
How much minutes I have? I finish?
If you could come to the conclusion.
Las conclusiones.
Okay, conclusions. I can read the conclusions if you allow me to do so. The stabilization agreement is a dual nature contract, as I said. The scope of the agreement only applies to the Cerro leaching project, delimited by the feasibility study and their contractual interpretation in accordance with Peruvian law. The Supreme Court interpreted the 1998 agreement and the mining law and concluded that the scope of the agreement, and we cited paragraph 170 of the judgment, is limited to the investment project defined by the feasibility study, the leaching project. And this is what I've been saying. In the case of a breach of contract, you have to look at it from a contractual viewpoint and not from an administrative viewpoint. In the hypothetical that Peru had breached the stability agreement, it did not. The alleged breach materialized from the moment SUNAT's assessments were notified to SMCV. And that is why I mentioned here at 39 that the contract breach has to be looked at from the viewpoint of the administrative law and not from other viewpoints. There's only one breach here, and it has to do with the notice of the first assessments. Thank you, Madam President, members of the Tribunal.
Many thanks, Mr. Morales. We have, for the moment, no questions, so if claimant would begin with the cross-examination.
Yeah.
Do you happen to have a second one for respondent? Do you have a second binder for respondent? Thank you.
Good afternoon, Professor. Good to see you again.
Buenas tardes.
Good afternoon.
Professor, you are a civil law expert, right?
Yes.
And you have focused your practice on civil law, right?
Yes, yes. My professional practice in 10 years, well, I have seen a number of matters, not only civil law, but also constitutional law and other things as well. I'm not necessarily linked to civil law. The civil law coincides with other matters, other different matters as well.
I've reviewed your CV and I have not seen any publications on mining law. Did I miss something?
No, indeed. I don't have any publications on mining law.
And you also do not hold yourself out as a mining law expert, right?
No, of course not. Civil law expert.
So let me show you first report paragraphs 25 to 27. We have it here. You make there an analysis of the mining law and regulations to determine the stability agreement scope, and you reached a conclusion that was, I quote, the mining law and its regulation expressly restrict the scope of the stability benefits granted through the mining stabilization agreements to the activities related to the investment projects for which the agreement was entered into. You see that here?
Let me see. Just one moment, please. One moment.
Comfortable. That's paragraphs 25
Sí,
to
secretario.
27.
Este es. Sí.
Yes.
Sí, sí, párrafo 20.
Yes, yes. I found paragraph 25 to 27.
You base that conclusion on some bullet points that quote from selected provisions of the mining law and the regulations. Maybe we can show the next page as well. You see that?
Sí, sí.
Yes, at 25, I cite Article 79 of the Law on Mining, Article 81 and Article 83 that talks about investment programs, and 83 in particular talks about the effect of the contractual benefit, goes exclusively to the investment. Article 84 says, speaks of the project. Article 85 speaks of the feasibility study. Articles 82 and 83 say that Article 5 clearly says it. The title holders, in order to enjoy guaranteed benefits, shall submit a technical economic feasibility study. And the regulation, I cite Articles 22 and 24, which speak of investments. And
Allowed.
No, simplemente estoy mencionando
I'm just mentioning.
el resaltado, ¿no? El resaltado.
I was just highlighting aspects.
Okay. Let me ask you a question. So my first question is, the conclusion that you reach in the first sentence of paragraph 25, do you base that on a reading of the provisions that you cite here in the bullet points that you cite in paragraph 25 and 26?
Sí, me ratifico.
Yes, I reiterate what I've said at paragraphs 25 and 27. I said this at the February hearing. Those of us who are specialists in civil law do something that many legal specialists don't do. We are looking at the law, and like anyone who interprets the law, we interpret these articles, and according to the result of my interpretation is that in order for a mining title holder to be a beneficiary, they must present a feasibility study. That's my interpretation. Now, 27.
We all want, it's 5 o'clock now, we all want to go out. If you make long speeches after each of my questions, we're going to have to sit until 9 or 10. Nobody's going to be happy. So just listen to my question and try to answer my question, okay? Did you select the provisions of the mining law and regulations that you list here, or did council provide you with that list?
I am the one who personally prepared my 2 reports, and I can tell you that as an arbitrator, in the arbitrators, I've done it alone. I'm not with a team and with a law firm. So the professional academic work that I do it alone.
So you're testifying that you drafted those 2 paragraphs, Professor?
Yes, indeed.
Is there any reason why you omitted Article 82 of the mining law from that list?
I have not cited certain provisions of the law and the regulations because I thought these would be relevant to get a key idea, which is, well, I had to look at it, comparing it with the stability agreement and the judgments of the court. And as I've stated in my presentation in my 2 reports, what I interpreted based on those provisions of the law are in keeping with my final conclusions.
Do you know what Article 82 of the mining law is about?
Right now, I don't have it at hand. I would not be able to tell you the content of that provision.
Professor, any reason you did not include Article 2 of the regulations, the mining stability regulations?
As I explained, I selected those provisions that backed up what I had to say in paragraph 27, which is to say that the guarantees for mining title holder are based on the presentation and approval of a feasibility study. That's what I say. I could have selected more provisions, but I wanted to put forward a preliminary idea as a hypothesis and then corroborate it with the other activities I performed, interpretation and studying the judgment of the Supreme Court of 2017. So these activities corroborated what I said in paragraph 27.
What Article 2 of the mining regulations is about?
No. If you show it to me, I would not be able to tell you the content.
Omitted the second paragraph of Article 22 in your list?
No, there's no reason. I simply wanted to highlight the question of investments. And since no mention is made of them in the other paragraph, that's why I didn't mention it. So I cite these provisions as examples. These are not, one doesn't necessarily have to cite them. So looking at these provisions, this is my conclusion. And that can be confirmed by interpreting the stability agreement and by analyzing the 2017 decision of the Supreme Court.
Professor, do you know what the Mining Council is?
Yes. Yes, it's a final administrative instance.
Have you reviewed any of the decisions of the Mining Council before you reached that conclusion?
No, I have not done so.
Have you reviewed any decisions of the Directorate General of Mining, of MINIM, before reaching that conclusion?
No, what I've reviewed, as I say, are basically the most important documents that I've analyzed. Well, apart from the mining law and the regulation, have been the Stability Agreement of 1998 and the Supreme Court judgment of 2017.
So you also have not reviewed any decisions by SUNAT, for instance, that go to the issue of the scope of stability agreements, have you?
I have reviewed some, those that are related to the case, not all of them, but especially the 2008 royalties case. But I have not gotten into an analysis of SUNAT's decisions. I have not analyzed in-depth decisions by the tax tribunal, but I understand that they've been based on a legal foundation. And I think that is for the tax law experts, but I'm an expert in civil law. So it wasn't relevant for me to give an opinion about administrative rulings, as that goes more to tax law. That's why I've not analyzed the administrative resolutions of the SUNAT or of the tax tribunal. I repeat, I have looked at the 2017 judgment and the stability agreement.
And just to be precise, when you said you looked at some SUNAT decisions, you're referring, I think you referred to the ones of Cerro Verde that relate to Cerro Verde, the royalty decision in the 2008 case. Is that what you were saying?
Yes, it's in the 2017 judgment, some of the background is mentioned. But in Peru, judgments, unlike in other countries, there's not very much of a description of the facts. There's a summary of the facts, as in the case of some of the tax tribunal decisions. That's what I made reference to, but it's not that I had the rulings of the tax tribunal before me and have read them and analyzed them, because that's not part of my legal analysis. Those are tax law issues.
And you're not an expert in tax matters?
No. No, I'm not a tax law expert.
You haven't reviewed any SUNAT decisions that relate to other mining companies where SUNAT applied stability agreements or the mining law to in the case of other mining companies other than Cerro Verde?
No, because as I say, the purpose of my two reports has been to undertake a contractual analysis. As an expert in civil law, I'm here in this case as an expert in contractual interpretation.
Okay. Let's look at paragraph 59 of your first report. You say here that I agree with Dr. Bullard that the stabilization agreement is governed by a special legal framework. It reflects the guarantees granted by the mining law, and therefore the systematic interpretation must be particularly stringent to avoid restricting or broadening the special legal framework applicable to the contract. In other words, the interpretation closest to what is provided in the mining law must be preferred over one that deviates from said law. So leaving aside all the adjectives that we can give to interpretations, hermeneutic interpretation and objective, etc., is it still your position that the interpretation closest to what is provided in the mining law has to be preferred over one that deviates from said law?
The example I just cited, when one interprets Article 36, for example, has to be interpreted broadly. And what is the others here agree with me. SMCV is not an adhering party. It's not a vulnerable party. That's what I'm referring to. There are other considerations.
What was that, a yes or a no answer? Do you still agree with that statement?
Of course. The paragraph you have cited, I wrote in general terms. It is not being applied to a specific case. I can cite a specific case. You can't render an interpretation contrary to what the law in mining says. And I said this at the February hearing.
Your answer was yes?
Yes, it agrees with paragraph 26 of my report. What I concluded in paragraph 27 and what I also said in paragraph 39 of my second report there, I say that the guarantees are applied exclusively to the investment programs. That's what I'm referring to. Now, evidently, that's a general assertion by Mr. Bullard, but here one begins to specifically, when one gets to the specific interpretation of the stability agreement, there I don't agree with him.
Okay, we're going to get there. We're going to get to more concrete things. But that statement was made in a specific context of the Cerro Verde Stability Agreement, correct? It says, I agree with Dr. Bullard that the stabilization agreement in capital letters, that is referring to the Cerro Verde Stability Agreement, right?
Of course, the legal framework establishes the guarantees in favor of the mining title holder, so long as they present an investment plan that's approved by the authority. That's basically what I'm arguing in my two reports.
And it's still your testimony that any interpretation, you call it a systematic interpretation, but any interpretation of the stability agreement must avoid restricting the framework, the special legal framework, or broadening the special legal framework. Is that still your position?
Of course, the guarantees can't be mutilated by the state. The guarantees are immutable. If a mining title holder has a stability agreement and they have their feasibility study, then the state has to respect those guarantees because it's a benefit that they've received on an exceptional basis. That's in the law in mining. Yes, but it's also a matter of the policy, so it's not sufficient to interpret the law in mining, but also a private person is protected by guarantees in a contrato ley. So how can a stability agreement in general not take into account this immutability, this immunity, this privilege that private persons have? In that regard, that's the gist of what I'm saying. One mustn't remove these from context, but I begin speaking about the stability agreement in general, and there I cite, that's the quote in my report in paragraph 24, just as I anticipated, and not just that law, but everything that follows up to paragraph 63, where I explain what I mean. So if I take that paragraph in isolation, one might say, so you're in agreement with Bullard on that. But how can I not agree? Well, if the law guarantee supports the guarantees, how can I go against that? Sorry for speaking at such length.
So the rules of the game here is that you try to answer my question concretely, precisely, give the explanation you need in a few sentences, and that's it. Because if you're going to give monologues that span over several pages, we're not going to leave here before 10 o'clock, or we won't have the opportunity to ask you any questions because the tribunal's probably going to kick us out at some point. So let's let's stay focused. Listen to my question and try to answer it as concisely as possible. So, when you say avoid restricting or broadening the special legal framework applicable to the contract with the special legal framework, you mean a mining law, right?
At paragraph 59, yes, no doubt. I'm talking about the mining law.
And the reason why the stability agreement must be interpreted closest to what is provided in the mining law is that the stability agreement is an adhesion contract, right?
Article 36 of the General Law on Mining says that, but the second paragraph refers to guarantees. So I repeat, this has been corroborated by the Supreme Court when it has developed its interpretation regarding control preferendum, which is not applicable to the stability agreement. It is an adhesion contract with respect to the guarantees.
So I think the record said here Article 36. Were you referring to Article 86?
86.
86, yes, where I speak of adhesion contract, and the second paragraph speaks of guarantees. Paragraph 36 is the paragraph of the from the Supreme Court decision. Excuse me.
We're talking about Article 86. So you would agree that stability agreements are governed by Article 86 of the mining law, right?
Sí o no?
Disculpe.
And
No, ¿me puede repetir?
Could you repeat the question, please?
with me that stability agreements are governed by the mining law.
Yes.
And the mining law, as you mentioned, sets forth the stability guarantees, right?
Yes. It describes them, yes.
And the mining law also sets forth the terms of the stability agreements, right?
Yes, it mentions certain contractual clauses, no doubt about that. But the stability agreement, well, there is a model, as I've mentioned, that has to be filled in by the parties. And there are some cases where one must include the purpose of the contract and the investors I've mentioned in my report.
So do you know what the terms are that stability agreements can have? The duration?
Sí, por supuesto.
Yes, of course. Yes, the term, duration, the investment project. I think that was 14 to modify the contract. There needs to be an agreement between the parties. There are several clauses that establish, for example, this one, 14, is not in the law on mining.
Not to answer my question. My question was, do you know for what duration you can conclude stability agreements under the mining law?
There is a time frame established by the law. Every agreement has to establish the term. It depends on the investment plan.
That's your testimony, that the duration of the stability agreement depends on investment program?
Claro.
Of course, a term is established as per the investment plan, as the 98 stability agreement has, no doubt. And then after the time runs, one no longer has the benefits.
I see. Okay. The professor, the mining law also establishes the eligibility requirements for stability agreements, right?
Yes, for example, Article 19 of the regulation indicates what must be included in the feasibility study.
By the way, just to not leave you confused, would you be surprised to hear from me that the mining law sets the terms of stability agreements to either 10 years or 15 years?
Perhaps you show him the law because he seems to be confused.
Sure. I think there was articles 72 and 79. Yeah. So 78 and 92, 82, sorry.
Ya, pero no entiendo la pregunta, ¿no?
Yes, but I don't understand the question. I don't know what you're asking me. I have interpreted the contractual clauses, and I've reached my conclusion. But I don't know if you're asking me something about the mining law. It would have to be based on my report. If you ask me a question about the mining law,
Professor, I'm happy to answer that question. So you testify that the stability agreement has to be interpreted to what is closest to the mining law, that the mining law provides the legal framework of the stability agreement, and you have set forth in your expert report what the legal framework is. So that's why I'm asking you the questions, okay? Would you agree that the scope of the stability agreement is limited by the mining law?
my statement has been not based on Article 85 of the mining law, that the mining title holder, in order to be a beneficiary of the guarantees, has to present a feasibility study. Now, that's my argument. You're asking me about provisions that are not in my report. Well, in that case, I would have to review them. But as I say, these are questions which, in my view, are not tied to my statement. I've said that, but you want me to have me say that I've said something else. But no, I said specifically what I said. The mining law has to be the framework. Yes. What for? For the guarantees. If one wishes to be a beneficiary, you must have an investment project that's been approved, and it needs to be presented in a feasibility study. That's all I've said. But now you're telling me no, but the time frame, well, I'm sorry, I cannot answer something. Well, if you're referring to a law or a regulation that I've not mentioned in my report, I'd have to analyze that in order to be able to provide you with a technical and serious answer, which is what you deserve, and not just some random answer. I'm sorry for going on at length, but I just want to clarify that you're asking me about certain subject matter that I've not analyzed.
You testified that the interpretation closest to what is provided in the mining law must be preferred, and that you have to be particularly stringent to avoid restricting or broadening the special legal framework, which is the mining law that applies to the contract. And I'm asking you about the mining law, and you tell me that you don't know some of the provisions of the mining law that we are talking about, and that they are irrelevant. How do you square that with your testimony?
No, sí las.
I am familiar with them, but it's not been covered in my report. You are citing something which I have said that refers only to a conclusion based on the interpretation of the provisions that I have cited of the law and the regulation. I have said just one thing, that the law and the regulations provide guarantees to the investor if they present an investment plan through a feasibility study, period. That's what I've said.
Nada más.
Professor,
nothing more.
You base your entire analysis of the stability agreement on the affirmation that the stability agreement, that the mining law limits the scope of the stability benefits to investment projects. You base your entire interpretation on that one analysis that we just looked at before, which was in paragraphs 25 to 27. Let's take a look again to paragraphs 25 and 27 of your first report. Here in paragraph 25, you say, it should be pointed out that the mining law and its regulation expressly restrict the scope of the stability benefits granted through mining stabilization agreements to the activities related to the investment projects for which the agreement was entered into. And that conclusion is fundamental for your analysis, because you say you have to interpret a stability agreement in conformity with that definition. So I'm asking you now about that definition. Is that so surprising to you?
It's not surprising. It's what the Supreme Court has said at paragraph 170 of the judgment of the Supreme Court of 2017. They said that.
Let me ask the question. Would you agree with me that the scope of the stabilization agreement is defined by the mining law?
Yes, exactly.
Los proyectos de inversión.
In investment projects, it's an interpretation. You say, why did I not cite Article 2 of the regulation or Article 82? And I repeat, I have chosen those provisions that are based on this assertion at paragraphs 25 and 27. And this was corroborated with the contractual analysis of the stability agreement, and this is in keeping with the 2017 judgment of the Supreme Court. I don't know if I've been clear in my response. I think it's the third time I'm repeating the same thing.
I'm sorry. Look at paragraph 25. I mean, can show paragraph 26. Where do you cite the Supreme Court decision here?
I repeat, paragraphs 25 through 27 is an introduction of a literal interpretation of these normative provisions. And then what I've done is to interpret the stability agreement and the 2017 judgment. So it's not separate.
So your entire interpretation of the stability agreement is based on this one conclusion that you reach here. That's what you base your interpretation on. That the mining law limits stability guarantees, according to you, to an investment project. Isn't that the case?
If you'd like, we can look at Articles 25 and 27. Something else I haven't cited, Article 170 of the Supreme Court decision says what I say in Article 27. So you say I didn't analyze it. Well, the Supreme Court said it. So there is agreement. But if you want to take as the key relevant point that interpretation, recall, I'm a professor of civil law. I'm an expert in contract law. So I have respectfully answered your questions that I'm not an expert in mining law, but there is no national doctrine in mining law that interprets these provisions. What are our sources for interpreting the mining law and the stability agreement? The 2017 Supreme Court judgment. Whether we like it or not, the Supreme Court has rendered an interpretation. And as I say, there's no doctrine in mining law in Peru that says anything different from what the Supreme Court has said. And the Supreme Court has correctly, in my opinion, interpreted the scope of a stability agreement. Now, if you take issue with my opinion, that's another matter.
As I said, we have to be brief. How can you say, on what basis do you say that no existe doctrina when you just testified that you did not look at any mining council decisions, you did not look at any SUNA decisions, you did not look at any DGM decisions to reach your conclusions, only at the Supreme Court decision? What's the basis for your statement?
Bueno, el Consejo de Minería es un órgano administrativo.
The Mining Council is an administrative body, and the Supreme Court is the highest court. They have interpreted this.
Did you cite the Supreme Court decision in reaching that conclusion?
Bueno,
I cited it in my report. I analyzed the decision.
Go back to where I was before we we went back to the paragraph. You agree with me that the scope of the stability guarantees, to what they apply, that the scope of the stability guarantees is set forth in the mining law?
That is not what he said in response to a question that you
It
asked
doesn't matter,
many
then I
times
ask
of
him
him.
the question again. Do you agree that the scope of the stability agreement is defined by the mining law?
What do you mean by the scope? Could you please repeat the question?
Okay, let's look at your first expert report, page 50.
Sorry, page or paragraph?
Page in this case. It's a second bullet point on page 50.
Are you
Let me see whether
the Spanish or English?
it's in English. Pardon, I'm just looking for the equivalent in Spanish. It's on page 50 in. Yeah, it's page 50 in Spanish as well. It's the third bullet under conclusions. Does this refresh your memory that it was, at least your testimony, that the scope of stability agreement is limited by the mining law itself, Professor?
Yes, I repeat, Article 85 provides for that the guarantees, the title holder of the guarantees will have contract benefits. There are the guarantees if the feasibility study is presented and it is approved. And I referred to that conclusion, and that conclusion is also in my information.
Guarantees to all investment apologies. The sentence that follows, the mining law does not grant guarantees to all investment projects executed by an investor, etc. That again is the conclusion that we just saw that you reached in paragraph 26, right? And 26 and 27 that we looked at. Is that right?
No lo he entendido, disculpe.
I don't think I understood your question.
That the sentence that follows the first sentence that states the mining law does not grant guarantees to all investment projects executed by an investor or mining activity right title holder during the term of the stabilization agreement. Rather, the scope of a stabilization agreement is applicable to the specific investment project for which the contract was signed, and in particular to the investment projects included in the feasibility study. That sentence is the conclusion that we looked at, that you had reached in paragraphs 25 and 26 of your first expert report, that same expert report, right?
Yes, of course, of course. Once again, the investment project was part of the feasibility study, and it had to be approved by the mining authority.
Your conclusion, Professor, and sometimes I just have to speak.
Pero no me deja responder.
But you don't allow me to answer.
I'm just, Professor, somebody disagreed with your conclusion and put in here that the mining law applied to mining units and concessions. Then the scope of the stability agreement would be defined and limited to concessions and mining units, right?
Well, I heard someone say that, but I do not agree. Dr. Otto mentioned that, but we don't see that in the stability. Rather, Dr. Bullard said that, but I didn't see that. In my opinion, when the contract refers to this, it is referring to the location. It's very colloquial expression, is meaning where it is located. And this is the way we use it in Peru. When it says circumscribed, it's not the interpretation by Mr. Bullard.
And again, that's based on your conclusion in paragraph 25, which you reached on the basis of those selected articles of the mining law without consideration of what the Mining Council decided, without consideration of what the DGM decided, without consideration of what SUNA decided, right?
Yes, I told you that I did not review those administrative resolutions.
You're not a tax lawyer, is that right?
No, I'm not a tax lawyer.
Hold yourself out as an expert in administrative law, do you?
No, I'm not an expert on administrative law.
Paragraph 98 of your first expert report, you mentioned that SMCB's tax obligation arose when SUNET notified its assessments. Do you see that?
Sí.
Yes,
98, sí.
at paragraph 98, yes.
Have you considered Article 2 of the tax code when you made that statement?
No, as I said in my presentation, I interpreted the general law and also the scholarly articles that I cite from tax law, because tax practitioners have also followed the Brazilian school of thought. I cite two of them. Carvalho is one of them, and I think he was translated by one of the experts, Jorge Dracuch, who will be here. So here it says that an administrative act is the one that supports the law, and at the same time there is efficacy. But again, what does Article 2 of the tax law provide for? It is on the screen. Article 2 refers to the origin. I can see that. Yes, I see it on the screen. Thank you. Professor.
Brazilian scholars rather than on the Peruvian tax code?
Well, they were translated because they are applicable to Peruvian law, and that's the reason why it was also applied by one of the experts. Brazilians refer to the obligation, the tax obligation that has to start and also be valid and applicable. And here, Article number 2 is referring to the emergence of this tax obligation. I have said that this tax obligation is enforced when it is informed to the taxpayer, and that was my conclusion.
Case about Peru. Any reason you did not rely on the tax code in reaching that conclusion, but on Brazilian professors that talk about Brazilian tax law?
Well, but there is a general law, that is Article 1374, that indicates that any unilateral act becomes enforced whenever it is notified, whenever notice is served. And this is also, when can we say that this act is to be enforced with the notification? So the taxpayer clearly can present a complaint.
Tax law. You know that a tax obligation arises when the taxable event occurs? Would you agree with what Article 2 says?
Yes, of course.
You also mentioned interest payment. Do you know that interest payments arise when the taxable event occurs?
Yes, of course.
So any reason why you suggested in your report that well, it's fine. So you're analyzing the date of a breach, Professor, right?
Sí, sí.
Yes, basically it was a civil law analysis, and clearly it had to refer to the general administrative law, that is the law, the framework law to apply to the tax code. So an administrative act is approached from that point of view.
Report is what is the date at which the stability agreement was breached on the hypothesis that it was breached, right? That's the analysis that you're making here, right?
Yes, indeed. As I have already said, if there was a breach by the Republic of Peru, it would be on the first day that the first breach was informed or notified.
Professor, if you analyze a breach, if you work under the hypothesis that there was a breach, there was no tax obligation, and interest didn't start to run. You can't have both the breach of the stability agreement for the imposition of a tax obligation that was contrary to the stability agreement, and at the same time an obligation of the tax of Cerro Verde to pay that obligation. You either have the obligation, and if there's an obligation, there's no breach, or you have the breach and there's no obligation. You can't have both at the same time, right?
Well, the contract obligation Peru had to comply is different with the obligation the taxpayer had when the notice was served of the assessment. If the taxpayer considered that that assessment and also ongoing assessment lead to an economic prejudice, then there are the right paths to counteract this through an administrative act or some other way. Because in my opinion, the resolution in itself has a tax obligation. It includes the interest and also the breach, the hypothesis that is mentioned in the code. So they say, okay, this is the hypothesis, there is a breach, so I serve notice, there is a breach of a tax law, for example, and in my own opinion, that is the beginning of the legal power that a contracting party has to sue the state if there is a breach of the stability contract.
When does the obligation to well, let me put it that way. When does the assessment become enforceable under the Peruvian tax code?
I just said it with a notification.
No, está en mis...
It is in my reports. And I also said it in my presentation.
Are you aware? Have you reviewed Article 115 of the tax code?
I didn't include it in my report, no.
You don't know what Article 115 of the tax law says?
Well, that should be done by the tax experts. As an expert on contract law, I said if there was a breach, a contract breach by the state, when that breach occurred, and my answer was when the first instance was informed. And it agrees with what Dr. Bullard mentioned. His example, in my opinion, tells me that I am right. If there are several cases of non-payment, or if there were several assessments that were not agreed by the title holder, with only one breach, there is an act.
Without knowing what Article 115 of the tax law code says, right?
No le mencioné.
I didn't mention that in my report.
Would you agree that each SUNET assessment is independent? gives rise to an independent administrative act?
Bueno,
Well, this is the same example that Dr. Bullard used, and it is useful to answer there. So they are different, and they're different also in time. And I also mentioned that there's only one breach.
Complimento right now. I asked you, would you agree with me that under Peruvian administrative law, each SUNAT or each assessment by the tax authority gives rise to an independent administrative act?
Unfortunately, you didn't allow me to conclude, but from the administrative point of view, yes, there are several assessments that are independent, but from the contract point of view, it is just one act, the breach of the stability contract agreement, if it was breached in this hypothetical.
So, putting aside, we're gonna come to the question of breach, but you would agree with me that that each assessment by the tax authority gives rise to an independent administrative act. Is that a correct statement or not?
I said that in my presentation. I showed that contract law and administrative law. It is in my presentation.
In your first report, you agreed that Cerro Verde could have initiated a separate contract claim before Peruvian courts for each of the SUNAT assessments, didn't you?
Can you point?
Yes, it is again on page 50 that we looked at.
en el párrafo 108,
Is it paragraph 108?
108,
It's the bullet points that you have.
108.
Sorry?
Ah, ya, en conclusiones.
Yeah, it's in the conclusiones.
51.
In Spanish, it's on page in español.
Page 51, ¿no?
Page 51. It's
Sí, 51.
Sorry, in Spanish, it's on page 51.
Yes.
And you see here, you said via SUNAT's notifications, the taxpayer could exercise its right to file claims for breach of contract before judicial bodies. You see that?
Sí.
Yes.
You used claims, not a single claim, did you?
I may have said to present claims, but I didn't mean that there are several breaches. I do not refer to plural claims in the plural form.
Let me point you to paragraph 108 of your first paragraph 108 of your first expert report, which is right before here, before the bullet points, the conclusion points. Here you say, consequently, the statute of limitations for exercising actions based on alleged breach of contract before the judicial bodies began to elapse from the moment SMCV was notified of the assessment and penalty resolutions, since it was at that moment that the breach occurred. You see that?
Sí, sí, no.
Yes. Yes, it is true. 108 refers to actions, and at 51, I referred to claims. Yes, why? Because given a contract breach, Peru, there may be a claim for a compensation or for a contract breach, and I was not referring to that, but I am clarifying that whenever there are actions or claims, I am not saying that given so many assessments, there should be separate claims. I'm saying that given the first day that that assessment is notified, there may be a claim, several claims. There could be a claim against the breach, for damages, or the termination of the contract, but given one act, that is the first notification of the assessment.
Professor, that's not what you're saying here. What you're saying here is that there are...
Bueno, le estoy me está preguntando y le respondo.
You're asking me...
My question first, okay? What you're saying here that SMCV that the statute of limitations for exercising actions based on alleged breach of contract before the judicial bodies began to lapse from the moment that SMCV was identified. You, when you wrote your first report, and I can walk you through additional provisions, you asserted that there were independent breaches for each of the agreement, that you only later on decided to walk that back, didn't you?
That is your interpretation, and I do not agree clearly. I say that it is just one breach. If you think that I have said the contrary, I respect your opinion, but I disagree.
That's still what you're believing. You said today on the transcript at 16 minutes 53:34, you said, I only have the Spanish here, si hay sucesivas.
If there are successive notifications, it is something that would have to be, that all of the claims would have to be put together or accrued.
About todos los incumplimientos, all the breaches for the successive notification. So you still believe, when you don't pay attention, you still believe that there were separate breaches, right?
Para nada, justamente
Not at all. The example that Professor Bullard offered showed that there are several breaches. I'm saying that there was only one. When I'm saying that they are accumulated, I am not going to claim just because of the first breach. Once I claim, I am going to put together all of the breaches, not just because the first month the tenant did not pay the rent. You're not going to present 20 claims for 20 breaches. The breach is only one. The rent was not paid, and the same thing here. There is only one breach.
Professor, you just said 20 breaches. You just said you're not going to present 20 actions, but you could, because there were 20 breaches. You just said it again, Professor. That's what you believe.
No, al contrario.
Quite the contrary. There is only one. The rent was not paid. So someone, I'm saying under Peruvian law, someone will present a claim due to the breach of the lease contract, and when 20 months were not paid, 20 claims will be brought forward? No, only one, asking for the payment of the unpaid leases. And the same thing here. If there are 20 assessments, Cerro Verde has to claim for the breach of contract, and they are going to say these are the assessments.
Let's move to the next topic. Let's talk about the Supreme Court decision that you had mentioned. Sorry. You would agree with me, and I think you mentioned it today, that the Supreme Court judgment does not create a binding precedent, right?
Agreed.
And you would agree with me that any court that reaches a conclusion that is different from this, well, first of all, that courts can reach a decision that is different from the Supreme Court, so long as they justify that different decision, right? Rephrase that and let me be more precise. Any court that reaches a conclusion that is different from the Supreme Court's decision in the 2008 royalty case could do so long as the court justifies why it reaches a different decision. Is that correct?
As I have said before, this judgment is an appeal judgment. So the Supreme Court verified whether the justices at the higher level and at the appellate level have breached the law, and they interpreted the stability agreement, and they interpreted the mining law. You're asking me, there could be another appellate court that says the same, but in my opinion, there is no interpretation that would allow us to get to a different result.
But I asked you. I asked you whether a court in Peru can reach a different decision than that in the 2008 royalty case.
Bueno, sinceramente,
Honestly, I do not want to be arrogant, but I do not find an interpretative argument to contradict what the Supreme Court of Justice said.
Your second report, paragraph 94. You say, at present, the Supreme Court's interpretation with respect to the agreement in the context of the mining law has not been the object of dissenting opinions by any other court in Peru. Although this could occur in light of the Supreme Court's judgment in the 2008 royalties case, any court that reaches a conclusion that is different from the Supreme Court's must justify it. It cannot simply ignore what the Supreme Court has held, as Dr. Bullitt seeks to do. So it's your testimony, isn't it, that a court can reach a conclusion that is different from the Supreme Court so long as it justifies it, right?
discúlpeme, tengo acá el
I apologize. I have the report. Is it the second or the first one?
segundo, está
Paragraph
en el primero.
94.
Sí, disculpe. No, sí.
Yes, of course.
You still
¿Me
agree
deja,
with
me
that
deja
statement?
responder?
Would you allow me to answer?
No,
So
pero
you still agree
déjeme
with that
responder
statement?
Let me answer the question.
Here's
que-
my question, Professor.
Le escucho, disculpe.
You still agree with that statement, Professor, don't you?
My answer is also what you asked me, whether it is a binding precedent, and I said no.
Arbitration. And you said the same thing in the SMM arbitration. Here's the transcript that's claimant exhibit 1141, transcript of the 9th day in Spanish, page 2469, lines 22 to 2470, line 8, and in English, page 2340, lines 8 to 13. So you said the interpretation of the Supreme Courts thus far has not been contradicted by any other court in Peru as far as I know. It could happen given that the Supreme Court judgment in the 2008 royalties case was already given, but a court that reaches a different conclusion must justify it.
If I may interrupt, can you tell us where in his binder is? Because you're only showing the English
Oh.
and he should be reading the Spanish.
Yeah, we can put the Spanish also up, but it's in tab 3, apologies.
Sí, por
And
favor.
again, tab 3, the Spanish pages were they're very small up. There are 2469, starting line 22.
Bueno, lo que pasa es que
Perhaps I've confused things. What it is what I said in February, and what it must be is that the Supreme Court may have an interpretation in connection with the stability agreement that is different. But I said there is no legal reason, well, unless there's a justification, but I cannot find a justification. That is the must be. The situation, the current situation is that it doesn't have a binding precedent. It doesn't bind for the future, but it creates a very powerful argument in academia and in future litigations. To date, there is no legal scholastic opinion in Peru that has questioned the Supreme Court judgment. That is an exemplary opinion. Judgment, in my opinion, because it interprets the situation, and I said this in my reports. It interprets the mining law and it interprets the stability contracts. I have said it in my statements.
Professor and members of the tribunal.
Thank you very much, Mr. Prager. Any questions in recross?
Can I have 1 minute, please?
I would like to use the time to ask just one question to you. Going back now, or going away from the mining law and what answers it provides on our question here. Do I understand that there is at least consensus between you and Mr. Boulard on the rules of interpretation under Peruvian law? I understand them to be Article 168, literal interpretation and good faith, Article 169, systematic interpretation, Article 170, functional interpretation, and Article 1361, global interpretation. Is this right? Insofar you and Mr. Boulard agree?
I disagree with the way in which he has understood the interpretation of the contract. He does not cite any legal scholastic opinion that maintains how the contract must be interpreted. In my two reports, I cited the legal scholastic opinion and comparative law that has influenced Peruvian legislators in connection with interpretation. The Italian Code has had a lot of influence in connection with interpretation rules. To understand what these interpretation rules mean, you have to read legal scholastic opinion of Peru and of Italy in this case. He talks about, venire contra factum proprium. I disagree with that. He talks about functional interpretation, but he interprets the law but not the contract. Functional interpretation has to do with interpreting the purpose of the contract. A theological interpretation has to do with investment, but that is the mining law. But the stability contract has its own finality, its own purpose, which is the investment in the concession, as the Supreme Court said. If you compare both reports, you're going to see that our interpretation perspectives are quite different, very different.
That I just wanted to verify that these are the articles we have to pay particular attention to.
That's exactly right. 168, literal interpretation. 169, systematic interpretation. 170, functional interpretation. 168, good faith in interpretation. And 1401, contra preferente interpretation. 1401, interpretation in favor of the adhering party if the provisions are ambiguous. This under 1401 of the Civil Code of Peru.
And you mentioned in your presentation the settlement agreement of 2001. Did you refer to the settlement agreement of the 30th of March 2001 between Cyprus and Minero Peru?
Where in my report do I talk about that?
Can you search for it, please? Maybe I have
Yeah, I don't really remember that settlement agreement in my presentation. I haven't mentioned that in my presentation that I can recall.
Maybe you have mentioned it in an answer to a question. We will check the transcript. I just wondered, and now when you talked about global interpretation, you say in your presentation, the shared intent of the parties can be discovered in their behaviors in the pre-negotiations, execution, and performance of the contract. And so I wondered, and now would something like a settlement agreement concluded after the 2098 stability agreement could be a factor to be considered in global interpretation?
Global interpretation, as contract scholastic opinion indicates, is subsidiary to the literal interpretation. If the literal interpretation does not work, I have to look at the conduct of the parties, the negotiation during the interactions in connection with the contract, and further on, if the conducts are relevant, Clause 14 of the Stability Agreement prevents that, because any contract modification has to be done by agreement of the parties memorialized in a notarized deed. Professor Bullard says that there are 7 conduct of the Peruvian state that would have generated reliance on the parties. If we were to apply the doctrine of venire contra factum proprium, then this has to do with conducts between the conduct of the party. But there is no agreement in connection with the primary sulfides project, and that there is no agreement as to that in the stability agreement.
Okay, thank you very much. This was more than 1 minute, so respondent, do you want to ask questions in recross?
We have no further questions, Madam President.
Then this concludes your testimony, as my co-arbitrators have no questions either. Thank you very much for your testimony, Mr. Morales. You are released as an expert in these proceedings, and we will continue tomorrow with the Peruvian tax expert. Yeah, just in terms of...
Thank you very much.
Thank you. In terms of planning, you decided that we start at 9:30. I think this will still be our starting time. We have also, the parties have agreed that we end tomorrow at sharp 5:30. So our secretary will circulate another time lock, because we could imagine that the parties want to avoid that at the end all time is used up, and then there will be no and time for cross-examination for the claimant on the respondent's damages expert. So we hope that the parties will keep this in mind.
Yes, thank you, Madam President. Just to say that it was respondent's position that it's an absolute drop deadline, the 5:30, whereas we said that we hope that we're going to be concluded by that point, and we will do our best to be concluded at that point in time. But we exactly want to avoid the situation that you just mentioned, that we, although we still have time left in our allocated time, do not have time to cross-examine the quantum expert. So I hope this will all work out accordingly. But I just say we don't want to be in that situation, and if that's the case.
We were discussing the issue in the tribunal. Is it possible for you to agree on fixed times for each party to use in cross-examination in advance? Say, we're going to use an hour 45, so you know you have an hour 45, and that way you can concentrate in the main topics. Because what we want to avoid is exactly having, as you still have time, to have one party using more time than the other one. Is it possible for you to agree in advance on time for cross-examination, particularly of the last experts, in order to be even, no, for tomorrow? Because you have actually you have 2 witnesses in the morning. It's 2 together in your case and 1 on your side, and you have 1 witness each in the afternoon. So you have exactly the same amount of witnesses. Is it possible to agree on fixed times?
I have to be a little bit careful, because Ms. Sinistera is doing the cross-examination, and she may kill me if I make any commitments. But we will definitely take that into consideration. We will try to work out something that goes in that direction. How it's exactly going to look, I don't know. I'm not promising that it's going to be exact times, but something that tries to achieve the purpose.
But you should. If not, we're going to have a problem there.
Yeah, we will work something out.
So it is highly appreciated, and we trust on the continued cooperative spirit of the parties, which made this hearing really very workable, given all the constraints. So we look forward to hearing from you on that tomorrow, and wish you a good night.
Yes. Thank you, Madam President. Of course, we will work cooperatively together on this issue.
Thank you very much. We will.